Gang members. Let's see. Let's see how we got here today.
All right, Mr. Malik, good morning, sir. Welcome.
How we got here today.
All right. Sir, do you have any issues of concern or that I need to take up before the state calls your client?
I do, Your Honor.
Okay, go ahead.
May I approach?
You may.
What it do, nurse? What's up, gang?
Good morning, Your Honor.
Good morning, sir.
Yes,
So
ma'am.
for the limited purpose of this issue regarding whether Mr. Copeland will testify at this trial, I am representing Mr. Copeland. Your Honor, I spoke with several individuals in the Fulton County District Attorney's Office before this case was indicted. And the Fulton DA's office was very well aware that I was representing Mr. Copeland. Apparently, they have had conversations with Mr. Copeland outside of my knowledge and presence. Now, I can't do anything about that because he talked to them without contacting me first. However, he did contact me yesterday and told me that he was being subpoenaed to testify here today. And I asked him what he wanted to do. His position had been and has always been that he wishes to exercise his Fifth Amendment privilege against self-incrimination. I have explained to him, and I learned this morning that apparently an immunity order has been entered under OCGA 24-5507, granting him use immunity for testimony at this trial. I would object to that proposition. And the reason is this. I know very well that the district attorney's office knew about my involvement in this case from the inception of this case. I spoke with Don Geary in 2021 about this matter. And he asked me whether or not Mr. Copeland intended to cooperate with the state. And what he told me is that Mr. Copeland would probably either be
Where it all went south.
a witness or potentially a defendant in this case. I spoke with Mr. Copeland. We had numerous conversations between myself, Don Geary, and Thomas Greiner, who's in the Fulton County District Attorney's Office, who was prosecuting Mr. Copeland for a separate matter. And Mr. Copeland has steadfastly said that he intends to exercise his Fifth Amendment privilege. I have also participated in a conference call regarding
Interest. And that is, and if you take a look at the footnotes, sir, I'm sure your attorney's probably explained this to you, that she has the purview of determining whether or not your testimony is needed for a particular trial. I don't even have that authority. Your attorney doesn't have that authority. You can't decide that maybe it's not really necessary. She makes that decision. So, and it's in the public interest. So you've been subpoenaed in this case to appear before and give testimony in this particular.
They should have known right here when they was explaining all this shit.
State has provided
He was
sufficient reasons as to why
he
you
was
are
gonna plead the
necessary
fifth
as
anyway.
a witness.
We're gonna see where it all went south.
It appears that you've been
How
subpoenaed to
did
appear,
we get
as a
here?
witness in this case, and that your testimony is
Woody ain't
necessary
supposed
in
to
the
be
public
here.
interest. So that's how we, as a due process, gets you to come to court. I mean, you were noticed as a witness. They've identified you as a witness. They've determined that your testimony is needed.
Let's see when he said cool.
Because of the fact that you have some concerns about what your testimony may indicate or could indicate in this case, and that's something that you and your counsel have talked about, and I'm not certainly going to inquire about that. But
and he's been inconsistent. So anything that he told the state in this preparation would be inconsistent statements, which is impeachment evidence under Brady. And the state, I presume, will claim work product. That's why Ms. Hilton didn't give us any of the notes. But work product of the state is typically not subject to compelled discovery, except to the extent that such notes may be exculpatory and must be disclosed under Brady versus Maryland, which is 373 U.S. 83. Well, that's under Franklin. And then Waldrop versus Head says that work product doctrine gives way to the accused constitutional right to exculpatory and impeaching evidence under Brady. So what I'm asking this
What's up, Eno?
to order the state to produce all notes. They had investigated. If they don't want to do that,
Eno.
I asked the court to do get a copy of the notes in camera inspection and then meet with us ex parte so we can tell the court what we believe would be inconsistent statements, which is impeachment. That's why I brought it up to the court.
All right.
Your Honor, as I discussed with Mr. Steele last night, I turned over the statement that I believe was Brady, which was what Mr. Copeland told me about an incident in which there was a theft. And I provided that information to defense counsel. Outside that, the state doesn't have any notes. And so there's nothing else to turn over except for what I did turn over. We do have one additional matter, Your Honor, which would be criminal convictions that I would like to address.
Okay, let's deal with the issue first. The first issue of the notes. Okay. Do you have any written notes from your interviews of Mr. Copeland? What Mr. Steele is basically saying is that Mr. Copeland's given a few, he said 5 statements, and that some of those may be inconsistent, which would fall into the category of Brady, or may fall in the category of Brady. So do you have any written notes that you or your team took that arguably would be work product, but that I would need to review to determine whether or not they are on Brady?
We do not have any written notes, Your Honor.
All right, Mr. Steele, then that satisfies that issue in terms of that. If I find out that there's any other additional notes, then I'll change the terms of
All right.
my consideration on that issue.
Your Honor, and I'll get you the case in a moment because I don't have it at my mind.
Let's see when Woody Lawyer first
But they're telling, I think they're saying
made his little
the
greater
only statement that they have that's Brady is the one statement they turned over already.
And Your Honor, furthermore, in addition,
Let's see.
Whatever you decide to do outside of what the court is ruling upon. Remember, the court can only rule upon what I see. Okay, and what I see at this point in time is a witness who, for whatever reason, may have some other reasons about his testimony. He has expressed those this morning. He said, "I'm going to invoke my Fifth Amendment privilege." The state came to me and said, "Okay, listen, we would like you to sign an immunity order under 24-5-507." They make that decision. So there are. I mean, I think that gets us to the point where we knew that, or at some point in time, that the state knew that he was going to invoke his Fifth Amendment privilege. So
absolutely knew it.
So, but in order for them to still get this testimony, which they believe that they need, they offered him immunity. So that's what we explained to your client this morning.
Didn't
So
Woody
whether or not he
testify
wishes
today,
to go ahead and still
the
invoke
first
his
day he
privilege,
testified?
that's his choice. But the statute's pretty clear.
I understand.
And I know you probably, and I know you have known you, sir, for at least two decades or more, sir. And I know that you have told him, "Hey, look, if you invoke, this is probably what's going to happen." And I suspect that if you probably have a conversation with him now, you're probably going to tell him, "Well, that was a self-fulfilling prophecy in terms of what I told you might happen." But I don't know what conversations you have with them, but I suspect that they were consistent with what the dictates of 24-5-507. Now, Monday, we'll go ahead and I'll call him out before the jury comes in on Monday morning, and we'll ask him whether or not he wishes to continue his testimony, because I don't want him to invoke in front of this jury.
All right, so we ain't seen Woody Lawyer
I can help it. So
day,
since
right?
he's made it once already, I'm going to ask him before the jury gets out here on Monday, is your intent to invoke your Fifth Amendment privilege? If it is, he's going to go back into custody until he's willing to go ahead and give testimony, because he has immunity, so he has to testify.
Judge, the only thing that I would say is that the primary reason Mr. Copeland is in custody right now is because the state has utterly failed to follow up with me in any regard with regard to what Mr. Copeland wants to do or intends to do.
I suspect that that's probably not true.
It is grossly unfair.
I've known you for almost 2 decades. I've known Miss Hilton and Miss Love in particular for a long period of time, and I don't think that they would do that to you.
Judge, at no point did they ever reach out to me about Mr. Copeland. About Mr. Copeland's testimony here today. The last time I heard from anybody in the Fulton DA's office was June of last year.
Ms. Hilton, did you reach out to Mr. Melnick? And if so, when?
when I talked to Mr. Copeland, he told me Mr. Melnick was not his attorney. So that is, I talked to the witness because
When did you talk to Mr. Copeland?
last Friday, because my understanding prior to that is
Just
that
when it
Mr.
started
Melnick
getting
had told
rough.
Ms. Love that he wasn't his attorney. So when we went to go serve him, I understand that he did not have an attorney. When I met with Mr. Copeland, and this is Friday evening, Mr. Long and I went to go meet with him in the car. We said, hey, I think Mr. Melnick's your attorney. He said, Mr. Melnick is not my attorney. He said, I haven't even talked to him. And then that is when we proceeded to begin our conversations. Anytime Mr. Copeland did not want to speak with us, we did not speak with him. We called him on Monday to see if he could come down here. He said he didn't want to come, or he didn't respond. We left it
Now,
alone.
Woody
On
say he
Tuesday,
ain't
when we
say
picked him
he
up for
ain't
the
had
first
no
time,
attorney. He
on
said he
Tuesday,
didn't
when he
talk
did
to
not
his
take the
attorney.
stand, we went upstairs. We had some conversation. We left. Mr. Long took him back home, and then yesterday he came back down here with us again. We showed him some of the evidence that we were going to show him, and that was the extent of it. And if at any time Mr. Copeland would have told us he wanted his attorney present, we would have called Mr. Melnick. But our understanding was, one, he was not his attorney. Mr. Melnick disavowed being his attorney, and Mr. Copeland told me he wasn't his attorney. So that is what I based all of my decisions after. It was not until 6 o'clock last night, or whenever this email was sent from Mr. Melnick with Mr. Shard and Mr. Steele copied on it, that I get this idea that you've been talking to my client, and then my client's going to plead the fifth, which brought us here today. That has been what has happened since last Friday, Your Honor.
All right. So we have a witness that may not have been totally candid, or may not have thought that he potentially needed you. And as things developed, Mr. Melnick, he decided, well, yeah, he does need you. But whether or not.
And it's my understanding that Mr. Melnick called Mr. Copeland last night. So it wasn't that Mr. Copeland called Mr. Melnick. Mr. Melnick so happens to call him the night before he's supposed to testify. So I don't know what has happened or what has transpired, but that is the extent of what occurred.
So I'm not going to get into my conversations with my client.
No, and I don't expect you to. But I do want to remind you, Mr. Melnick, as well as I reminded both sets of counsel, that you owe a higher duty of tribunal to me and the court than you do anybody else. So please don't, you as a professional advocate, don't put yourself in a position where you come cross purposes with the rules. Okay.
Of course.
And that sometimes has to be explained to witnesses and clients. Okay. All right. So that's where we are at this point in time. Is that Monday morning? I will bring Mr. Copeland back out. It is. I don't.
What's up, Slick Rick?
The fact of holding him in contempt, but that's all I have at this point in time because he's been given immunity.
I'm just saying, day 87.
We'll take him up.
Woody
That's our first session of court. We won't be having anything else until then.
And Your Honor, I would like to ask that the court convey to Mr. Melnick, to convey to Mr. Copeland that he is subject to being committed and held in the Fulton County Jail until the end of this trial, because I'm certain Mr. Melnick, if Mr. Melnick wants to convey to us some of the concerns that he has, Mr. Melnick I'm certain is quite familiar with the statute under which the court has compelled Mr.
Hold on, Melnick, known as a bad lawyer in Atlanta.
Mr. Copeland, regarding
he a bad lawyer?
Any testimony we elicit from him on the stand.
Melnick, a shiesty lawyer?
Under the statute that the court has cited,
25507,
and that statute gives the court the ability and probably, depending on how the court feels about it, the absolute duty, given the necessity of Mr. Copeland's testimony, to hold Mr. Copeland in the Fulton County Jail until he decides to purge himself of the contempt of court by providing testimony. If Mr. Melnick would like to speak with Ms. Hilton or any other member of the state regarding his concerns about that order, which tracks the statute almost verbatim, then I would, because
she did say that
Mr. Melnick wants to convey to us some of the concerns that he has. Mr. Melnick I'm certain is quite familiar with the statute under which the court has compelled Mr. Copeland to provide testimony. So there is nothing that we could do to Mr. Copeland regarding any testimony we elicit from him on the stand pursuant to the court's order under the statute that the court has cited, 245507. And that statute gives the court the ability and probably, depending on how the court feels about it, the absolute duty, given the necessity of Mr. Copeland's testimony, to hold Mr. Copeland in the Fulton County Jail until he decides to purge himself of the contempt of court by providing testimony. If Mr. Melnick would like to speak with Ms. Hilton or any other member of the state regarding his concerns about that order, which tracks the statute almost verbatim, then I would invite him to do so. Otherwise, as I've stated, I don't see it being in Mr. Copeland's best interest to be confined to the Fulton County Jail until the end of this trial. But I will leave those matters to Mr. Melnick, who at this time is asserting that he is representing Mr. Copeland. But again, that was not the understanding that Mr. Copeland had previously given to us.
So
Mr. Melnick, if you do in fact talk to Mr. Copeland,
hold him in jail.
Like I said, I'll bring him back on Monday. We'll see where we are at that point in time. Okay. And he has the ability to purge himself by just providing testimony consistent with what he knows or what his knowledge of is in this case. Okay.
Judge, I have some personal matters that I need to convey to Chambers, but I'll do that off the record.
Okay, I'm going to recess it just a
Melanie
little
been
bit.
gone
and,
ever
but
since.
can you be back for Monday morning?
That's just it. I can't. Can I, is this something I can take off the record?
Well, I kind of have to call him on Monday. I do. I mean, there's no choice. I have no choice because that is the next session of court.
Judge, I have non-refundable tickets out of town on Monday. I can't be here. I cannot be here. And there's nothing I've had this on file with Fulton County since December 15th of last year. And again, had the state contacted me before today, I would have made them aware of this.
Well, there's one of those times as a lawyer that you're going to probably have to kind of figure out a solution, sir. I mean, I don't want to put you in this particular position.
I can't be here, Judge. I absolutely cannot be here.
Well, you have a choice. You can be here if you want, but you'll have to figure out some other things to do with your tickets. Gentlemen, jury, good afternoon. Okay, it appears that we have some more homework to do on behalf of all the parties.
Lawyer here. It has never been. I don't even like coming to court.
In the original condition that it was given to them.
All right, let's look
so
and
that we
see
may
when
properly
Steel
access
go off.
and evaluate
See, I
the
like when
content
Brian go off.
and the time and date and all of that, and the authenticity of those parts of the file have been extracted and purposefully kept out of what is given to the state.
This what I've
So
been
we are
waiting on
asking
this part.
again that the court compel either, you know what? And if they don't want to, then we're asking that they just be excluded.
Okay. All right, Mr. Steele, do you have the raw file?
I'm sick of this shit.
Judge Lamb,
Sir.
you allow another moment when Miss Love calls me that I cannot do something.
I
They
am
have the
fucking
exact
shocked.
image of what we got from the jail in Fayette County. That is it. And if I get another false allegation and you do nothing, I'm shocked. I'm appalled at you. I sit here day after day with this false allegation.
Machine.
Just machine. I gave the state everything. There's been no disconstruction. There's been no purposeful. I don't care. I don't care. I give over
care.
everything.
I
I've
don't
done this for
care.
33 years. Never in my life have I seen a trial. I've done 300 appeals in the state of Georgia alone. I've never read a case like this. Judge, I gave them everything I had. I waited. I was at my office till 8 after 8 last night. I waited for their investigator to come by. I handed him an exact copy of thumb drive. They had everything that we got from the Fayette County jail. There's been no deconstruction. There's been no purposeful exclusion. This is not the first time.
Okay.
And I apologize that I'm getting tempered, but I've never been treated like this. You talk about professionalism every week. Professionalism is lacking with one lawyer here.
Look at Short in the
Never
back.
been. I don't like coming to
Look at
court.
Short.
I used to love it. I would die for what we do. I used to say, I'm dying. I would die. I couldn't choose a better profession. If I had litigated with Miss Love, I would.
Your Honor, could we strike the
No,
hominem
no,
attack?
I'm
Really,
speaking.
could we strike that?
Okay, hey, everybody, calm down. Everybody,
This is
both of you sit. Both of you, please be seated.
Judge, I'm not.
Both of
done.
you, please be seated.
You have to do something. You have threatened me with contempt. You have threatened me with jail. If you go back in time, we can just start in voir dire. Jury after jury, you did individual voir dire, painful.
Man, what?
Miss Love would come in and
You
say,
supposed to say,
that
I'm
you're
mad at the
lying.
motherfucker.
It was not true.
This bitch
You
is
said,
this
that's not my
motherfucker
recollection.
lying.
I said it.
I'm finna knock
You
me
did
go
not.
out.
We start the
Okay,
case.
Mr. Steele.
I asked you, please.
Mr. Steele.
Judge, how would you feel if you were being treated
Mr.
like
Steele.
this?
Mr.
Oh, I'd
Steele.
like to finish.
Mr. Steele.
I gave them everything on that drive, and it's continual abuse of a prosecutor of another member of the bar. I don't talk with Miss Love.
I don't
And
care.
that's fine. I like that. But Judge, I'm not going to stand here anymore. I don't care. You can take my bar card.
Mr. Steele, I'm not.
That
Listen.
nigga said, take my bar card.
But they're.
They're like saying,
And this
take my
place, you know, to
EBT.
me, this is an innocent man. You talking about, Miss Love said there's a man in the Fulton County jail who shouldn't be there, Mr. Copeland.
This nigga shouldn't be there. This nigga
In
shouldn't.
charge, and we come here for a fair trial. It's been everything but that, according to that. Miss Love has tried to demonize me. At times, Mr. Adams. At times, Mr.
You
Shaw.
know,
All because she wants to win the case. And now she speaks over people. It's not right. I gave them everything. And by the way, and what
Bitch, I will not be silenced.
it's not even the law. If they call that gentleman on direct, I don't have to give them anything before trial. I do it because you asked me to. You said, listen, we got a big case. It's going to take a long time.
Like
Give them
Uno
things.
card.
I gave this, by the way, to the state October of 2023. October 2023, that was uploaded. Give it to the state. I hear about it now, and I
Okay.
wait there and I give them the exact duplicate of what we have. And now there's a
I know his
false
kids do
allegation
not
of
take him
misconduct.
serious.
And what I'm telling the court is what I said again. I do not appreciate it. And you have told it in front of the jury that I'm unprofessional. You were wrong. You based that on Miss Love's false
Your
representation.
Honor, again, the ad hominem attacks, Your Honor, I object, and he should stop talking when I object.
Try to silence me.
Yeah.
I will not be silenced.
But Mr. Steele, here's the thing. Okay, I think that Mr. Steele, please be quiet at this point in time. You made your point. You made your point at this point in time. Both of you, please be seated. Well, please be seated, sir.
and relax
I'm
yourself.
not done.
Please be seated.
Whatever you do is fine, but I care about Jeffrey Williams. It's the best scene.
It's sir, it's obvious. I would expect no less because you're his advocate, you're his champion. But could you all please sit down so I can kind of figure out a solution for this? All right. First, let me just kind of address the obvious. I know that tempers have been heated in this particular trial, and they continue to do so. And I know that all of you are being zealous advocates and representing your clients to the best of your ability with zeal. And
Are you sure this is what you want to do? And he said, yes, he intends to assert his Fifth Amendment privilege.
Let's see what Melanie came back up there talking about. Miss Weaver was fresh that day.
okay, counsel, is anything else I need to cover with you before we recess until Monday?
Got it.
Yes, Mr. Botts. Mr. Botts, you need to use the microphone, sir.
Is it working now? Can you hear me fine?
Yes, sir.
All right. Your Honor, we started this whole fiasco out with whether the state knew that Mr. Copeland was
Turn
going
it
to
up
take
for
the Fifth
bots.
Amendment when he took
No,
the
it's
stand.
old ass.
And if so, was that proper or improper to put him up on the stand, knowing that they were going to,
You have to speak up, sir. And if you could hold the microphone, it'd probably be better.
that he was going to assert the Fifth? And I know that they did know that he was going to take the Fifth because I heard it said outside right before I walked into court. I even said, the officer,
Then why didn't you, as an officer of the court, tell me before
I told you.
before we took his testimony?
I told Mr. Steele.
No. Why didn't you, as an officer of this court, tell me?
Well, then that's my.
I got a problem with you now.
Shit, I don't
No,
give a
that's
fuck.
I mean,
I got a problem with you now.
well,
I would suggest you don't say anymore.
I've already said,
Bitch.
I know that, sir. And the problem is, you should have told me if that were your case. Then you've just made an argument we didn't even need to have, because I could have certainly asked him based upon your proffer. Now you want to have it both ways. You can't do that.
Your Honor, I thought the state knew that,
And that's not what the point is. The point is, you as an advocate, is you should have told me.
You should have
Both sides
told
have an equal
me.
responsibility under the rules of professional responsibility.
okay, as long as we're both responsible, that's fine.
You should have
All right, have a
told me.
seat, sir. Thank you.
Is that okay?
No. What's your request, sir?
So in the attempt to avoid any spurious allegations moving forward, I would ask that Your Honor order that the deputies transport Mr. Copeland to the jail completely separate from any.
Yeah, thank you for reminding me of that. In our order, wait, just 1 second. In the order of the incarceration, I'm going to also have a keep separate order for him.
Your Honor,
For the transportation and the housing, because none of these gentlemen are going to say anything to him, but I don't even want anyone to claim that
Okay.
they did.
I think that that's fair enough, and that's a good suggestion.
we'll prepare.
Yes, Lieutenant Walker. So that will not be an issue? Okay. Okay. But we'll go ahead and have him, if you could also have him housed separately too? Okay. Okay. Thank you. Thank you, madam. All right. Anything else, counsels? All right. Take a couple deep breaths this weekend.
Take a couple deep breaths this weekend. I don't remember them sending him to jail today. I just don't remember.
Your Honor, here is that.
I'm okay.
Do you need any more time to talk, Mr. Copeland? Okay. What is your desire at this time?
I'm taking the field.
Okay, you're taking the fifth, but you've got immunity. But you
Taking
still
the
wanna-
damn
are you
film.
gonna testify? That's the thing.
That's the question.
That's the question on the floor. I've acknowledged the fact you have a Fifth Amendment privilege, but the state's giving you immunity, so that overrides that Fifth Amendment privilege. They require you to testify.
Yeah, but the state don't know what they're talking about.
They don't know what they talking about.
They implicate me. Then
Okay, they can't prosecute you on that. They can't. The order prohibits them from allowing them to use that testimony against you. That's what your lawyer, and I'm not going to get into any of the machinations or intricacies of what may or may not have happened in this case, but Mr. Melnick is a very seasoned criminal defense attorney. I've seen him over the past 2 decades. I'm sure that he's probably given you very, very good advice, but the state can't use that testimony. They can't kind of say, have it both ways, like you testify and then use that against you.
All right. You knew he was pleading to. You knew he was pleading to. So I'm gonna go find the next day. That Monday. And when everything jumped off, and we got here. KD, I'm gonna go to your page and look at and I'm gonna play our transcript. I'm just play a lot fast. Is that fine with you? Is that fine with you, KDD? I'm gonna need your link though. Look, KD. Okay, this was the day everything went down Monday. All right. I'm gonna play after I play day 88. I'm gonna go to your page and play our transcript we did. Cool. Judge look like he be breathing hard as hell. Hard and shit right now. Look at him. Trying to see if somebody smell it. He trying to see if somebody smell it. Hey, hold on, y'all. I thought they had
Mr. Copeland, have a seat, sir.
on the transcript. I thought they gave my boy a big jacket. You remember he was like, man, why y'all don't let them see me what I got on? Y'all trying to hide something? I thought they gave my boy a big jacket. It was a large.
Good morning again, sir.
Good morning.
Okay. Sir, it is your intent to testify today. Is that correct?
Yes.
Okay. All right. Some of our jurors, please, Sergeant Ingram.
Yeah, he said he wanted the people to see, but I thought they was gonna make him put on a jacket today. So they tried to make him change clothes, take off the chains and everything in the transcript. All right, come on, my boy.
What did you do after high school if you weren't working?
Say that again.
Did you do anything? If you weren't working, what were you doing?
I don't recall.
Okay. Are you married?
Nope.
Are you in a relationship?
Nope.
Right. Do you have children?
You know that.
Okay. I do, but the jury doesn't. Do you have children?
So ain't this
Yep.
right after the
Right. How many?
the ex
More than one.
parte meeting?
All right.
Ain't
You have more than
all of this right after the ex parte
I
meeting?
might. Ain't no telling.
Okay. That's fair. Do you have two that you know of?
Yeah.
All right. And how old are your two children?
All right, you know.
The same age.
What's that?
I don't know. Y'all been having me
Now I
here so
know.
long. I can't recall.
I know, but
Were you in jail on Friday?
if this is after the ex parte
Prior
meeting,
to?
Yeah, I was in jail Friday.
Were you in jail on
I
Thursday?
mean, they really got the order.
Thursday ain't came yet.
No, last Thursday.
I felt like it.
All right.
The ex parte
When you
went
were
another way.
when
with his
you
body
weren't in
language.
jail last Thursday, although you felt like it, how old were the children?
I don't know the ages.
Okay. Are you currently working?
Exactly,
I'm in jail.
yeah.
Prior to going to jail on Friday, are you currently working?
Nope.
All right. Now you talked about being in jail, which was on Friday. Prior to any of this, do you have any criminal convictions?
Of course.
Okay. Do you know offhand how many?
Don't keep up with it.
Okay. Tell the jurors the types of crimes that you've been convicted of.
Driving without license.
Okay.
My boy said driving without a license.
Driving with suspended license.
Okay. What else?
Ran in front of police.
All right. What else? Let me ask, do you have a theft?
I'm putting charges on me, so I go to jail for the charges y'all throw on me.
Okay. Do you?
We went to school together.
Do you remember which school?
I know one of them.
It was one of them. Okay. Was it elementary or middle?
Let's go down here. When it got juicy.
Of the sum and substance of the communication is for you to discuss the matter. Remember, I told you that it will be a violation for you to discuss the matter. Of the sum and substance of the communication, he's been disclosing that, however, and that's why I kind of want to know who told him that. So if he tells me who it is that disclosed that to him, he will be able to purge himself of that contempt, and he's done. That's the only thing I'm asking for at this point in time. If not, then as you well know, as a criminal contempt.
Let's see.
Information about any meeting, who was meeting, what the meeting was about, or whether the meeting was ex parte or not ex parte, who requested the meeting, who was in the meeting. We were completely in the dark. And quite frankly, we kind of remain in the dark. I am not a false accuser, okay? I do not just willy-nilly accuse people of things. So I'm not going to throw out spurious allegations like the ones that have been thrown at me over the past couple of days that are absurd. But I will say, Your Honor, what I do know is just based on what we've heard over the last 20 minutes, it appears there was a meeting that I knew nothing about that involved Your Honor, the district attorneys, and a witness who had been sworn in. My client was not given an opportunity to be present at this critical stage. This was a critical stage in this trial. That error is a foundational structural error in this case, and it is the cause for an immediate mistrial. Additionally, Your Honor,
Because that's what the state.
While I find this, I'm gonna ask y'all to keep it professional in my chat. Oh, here you go. I see it. I want y'all to keep it professional in my damn chat. That's all I ask. That's all I ask. So I'm nurse, get the booting people. If they do not keep it professional,
and this court were together, and Ms. Love made representations that John Melnick
right, so here
supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrienne Love, stating that Ms. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That never.
Mr. Steele, can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation.
All right, so this one.
How did you find out about any of that?
Well, I'm disturbed too, and the reason
I'm asking you a question.
And
How did you find out about it?
This
I'm
is
gonna
when
ask you a
all of it
question.
went left. After this, I'm gonna play the
If you look at
transcript
SCUDDER
on
versus State,
page.
which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somehow accurate based upon what you just said. We're entitled, Mr. Williams and every other person rolling charge here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me, and you and Mr. Adams meet with me, and others have met with me. It's those are ex parte for a lot of different other reasons, but I will certainly note that for purposes of record.
Well, I'm going forward. What I was told was that Mr. Copeland said,
And you haven't answered my question yet.
I'm not
How
going
did
to
you?
answer that question.
You're not.
No, I will not answer that question.
Why would you not answer that question?
Because I want to make sure that what I say is accurate. And I'm not trying to.
No. I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is
telling your ass
okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have this. I have problems right now.
Okay,
I
know what's your problems. Okay, at this point in time, all I'm asking you at this point in time is,
y'all heard that? Steve was about to say, nigga, we can have as many problems as we want. That boy had been taught some after he pulled that shit where he was like, I am shocked. Judge, if you do nothing, I am shocked. That nigga went and learned something because he was about to say, nigga, we can have many motherfucking problems you want to. You hear me? So I think they done juiced him up. That's why that nigga was ready to go to jail. Hell or jail. You know what I'm saying? Go on, let them finish though.
how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversations with a party. I mean,
a witness who was sworn in Friday. The court's telling, this is what I was told. If this is not true, not true. This court handed Mr. Copeland.
Tell me how you got the information.
Listen, whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this.
Really
I was told,
going on?
and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it
or
proprietary?
Information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court,
okay.
or excuse me, let me rephrase that. This court supposedly
Pay
said, I can
attention.
hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I
I'm doing
still
what
want to know,
everybody should
how
do.
did you come upon this information? Who told you?
What I want to know is why wasn't I there? Why,
Sir, I'm going to hold you in contempt if you don't tell me who tell me who this
I
information
don't
was
want to
come
be held
from.
in contempt.
Well,
I'm not
then-
answering that question. That's attorney-client privilege information. I am not answering.
Attorney-client privilege, unless you were in my chambers, that's the only way you can figure out.
I am
I
telling
tell you what, I'm going to give you 5 minutes. If you don't tell me
don't
who,
have to.
if you don't tell me who it is, I'm going to put you.
Well, let me-
I'm going to put you in contempt
I
because
understand.
that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information
I don't
supposedly
answer
from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
You got
Well,
5 minutes,
I
you know.
want to continue. This is what I was told. Mr. Copeland, made statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No.
Hey. Don't take my goddamn note. No. No. Don't take my goddamn notes. No. All right, so this where it went crazy at. This where it went crazy.
Your idea may be wrong, and you're asking me to listen. I told you the first time, and I'm not
Sir,
going to
I
breach that
don't
confidence.
want to hold you in contempt, but this is that serious.
Judge,
And
I know what it is.
you cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge, you listen. I'll do whatever you want to 5 o'clock or there.
No.
What I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing. And I'm moving for a mistrial. It is my understanding, based upon information belief,
From whom?
part of it.
From whom?
Well, I'd like to get the substance first. And
Bumpus?
then we'll
Okay, well then you'll be in custody until then because
Well,
because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
but you're assuming something because I told you already.
well, then, other than
Answer
if
that
you were
under
sitting,
attorney-client.
unless you were sitting in there with a recorder or Miss Love or Miss Hilton or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript. There's only one other person that's left.
Well, Your Honor.
And if that person gave you that
That was
information
Taylor.
or shared that information with you, she probably violated privilege.
Well, let me
y'all
tell
see how
you
he
two
said
things.
she?
One, I don't know how that is a privilege.
Y'all see how he said she? He knew it was a little bump. He knew it was bump. He knew it was bumpers from the get-go. Bump. He knew what it was from the get-go.
Privileged communication. It shouldn't
Well,
be.
it's because she has a client she's supposed to represent.
Who are you talking
But
about?
anyways, I'm not going to have
When I got this
I'm not gonna have any
information-
further- I'm not going to have any further conversation
Well-
with you about this. I want to know, the question still remains. I want to know who gave you the information?
I'd like to know what information happened outside of presence. That's
All right.
really it.
He can go into custody at this point in
I
time.
think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny.
Hey,
your
don't be
mo- I'm
coming
gonna
walking
deny
up on
your
my
motion.
boy
I'm gonna
like
deny your
that.
motion
I
for
understand
mistrial.
that you
Little
spoke with
bougie
a witness
thing.
outside our
Bro.
presence.
And whenever, yes, I
Big
had
neck
an
ass,
ex parte
bag up.
conversation, which is
And you-
appropriate.
and you
You walking
influenced
up
the
on my boy.
witness
Hey, watch how he
based on
look at
information
him.
belief, and I'd like to
Watch how
have
Steve
that all
look
on
at
the
this,
record.
the police.
I mean, I don't know why that's so hard to do. If nothing
Okay.
happened bad, that's fine. But you're acting like, tell
Watch how Steve look at the police like damn, nigga, you too close, bro.
me who it is and don't talk
What?
about the substance. Why can't we
Look,
have
y'all
an
see
issue
that?
that was
What you
outside of
doing?
presence? It should
Fuck
not
you,
have
bro,
been.
man.
Because
Nigga,
you got
bagged
some
up
information
then.
that you shouldn't have gotten.
Yeah, bag that ass
Why?
up.
Well, we can. That's for another day.
But why?
Okay,
Why
that's for
did we
another day.
exclude in the first place? I didn't know about this. So I
That's for
raised it
another
before
day.
the
So,
court. I raised it as soon as we found out about it.
well,
I gave you the case
Oh,
I'm
yeah,
relying on. I
Hilton
assume you read it.
glasses
If you didn't
off,
read it, you
rubbing
should
them
read it. It's a
eyeballs.
material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2.
okay.
That is a material or critical part of the case, and it's an automatic
Steele,
reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele, that is not that is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been
Right.
sworn. You know that I'm not telling you. I'm just saying if you read I'm assuming you read it. That's what it says, and you did it.
Does the
Supposedly.
state wish to be heard?
You said it supposedly.
Yes, Your Honor.
And what I'm trying to get to is
It
why
does.
did that happen outside of presence? And I need to have the
You say y'all think Kayla still can get in trouble if she just admit it was her? I don't think she can get in trouble at this point because they in more trouble. But at first, she probably could have. To be honest, I want her to get in trouble because she clout chasing. I want her to.
I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
You can't hide behind. Yeah, but the thing is, I think you got this information. Somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because unless you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or the party didn't give you the information.
On whatever.
So, Your Honor, but that's the issue, isn't it?
Well,
Why aren't we?
that leads to be told. But
right now, we don't know why we were excluded from that.
Mr. Steele,
and I want that information because Mr. Williams' constitutional right on the Georgia Constitution.
Just stop at this point in time, because
Article 1,
because you already said that. You've already said
Georgia Constitution, and we had a right to be present.
All right, Mr.
We're not waiving anything.
Yes, madam. Ms. Love?
Look, still finna get out her way, and I don't want her shit she gotta say.
And I know I said this previously.
Yes,
We are not accepting any proffer from this.
Okay, excuse me.
Okay. All right.
And they hate each other.
Yes, ma'am.
Your Honor, I am disturbed by
disturbed, bro?
Mr. Steele's.
You disturbed? For real?
Don't have any space, Mr. Steele. And plus, they're welcome to go to 8H. I mean, I told Sergeant Ingram that we can let in as many as we possibly can, that we'll fill up our benches at this point in time. We won't violate our security protocols, but that 8H is available. And
8H then has to have a right to counsel because they're here, and I'm not going to.
Do you have an attorney that's here for you, sir?
Sure. Ashley Merchant is here.
Sure.
She's the president.
Okay. All right. Well, we'll let Ms. Merchant in. That's fine.
Ashley Merchant.
Yeah, Ashley Merchant. All right. Ms. Merchant, good to see you as usual. I have told your client, you represent Mr. Steele, is that correct? Yes. For the purposes of the contempt, I've entered the order. I've entered the contempt already. I'm entering the order. I'm about to enter the order. I've held him in contempt earlier from today's proceeding by him not telling me who it is he got this information from. I'm not asking him for any of the sum and substance of the communication. He's been disclosing that, however, and that's why I kind of want to know who told him that.
Did Steele say this the first time he ever been held in contempt ever?
That disclosed that to him. He will be able to purge himself of that contempt, and he's done. That's the only thing I'm asking for at this point in time. If not, then as you well know, as a criminal contempt, there's no superseded bond, there's no appeal, and I'm going to put him in custody for this evening. And if he wishes to, which he can still purge if tonight Keith Adams emails me or you email me and tell me, well, it was X. So I'm going to give him as much flexibility to purge himself of this contempt. Only thing I want is, because of the way this information was disclosed, it is troubling to the court, and is since it was a ex parte communication. We won't get into the merits of everything else that Mr. Steele has proffered and everything else, but that's the only thing I'm trying to do at this point in time. So I've asked your client for the last time if he would tell me who it is that disclosed that information.
Judge, can you come up to the microphone? Sorry.
Please. Microphone, it'll pick up, madam.
What's up, Nona? What's up, Nona?
Which one?
It'll turn green. Yeah, it'll turn green. Yes, ma'am.
Is it on
What's
now?
up, Nona?
Okay,
What's
great.
up,
Thank you.
Bree?
Judge,
What's up,
just for the record,
Libra?
is the criminal contempt, is it criminal contempt that you held him?
The whole
in?
gang ain't here
And you
yet.
said you had a hearing earlier today.
How
No,
everybody
criminal
doing?
contempt. I told him what the contempt was, and that was he refused to tell, order the court. If counsel, as you know, if the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. I didn't ask or inquire about anything that was said. I just want to know who it was, because he's got too much detail of this particular alleged conversation for the court to be considered.
Do y'all want to hear Ashley go off on him, or y'all want me to get to what the transcript we did on KD page?
Entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list. And
Well, no,
notice of that.
criminal contempt is different. It is on the spot. So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had all day to tell me who it is that is it. So a little different, Ms. Merchant. I won't disagree with you, but
Well, and
okay.
Judge, just for the record, it's that's direct. So what you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding. And so it has to be referred to another judge. Doesn't require recusal. You actually have to sua sponte, send it to another judge because you are a witness to the proceeding.
Show me the case law that says that, Ms.
Yes,
Merchant.
it is in re McClarty. It's 152 Georgia App 399. And it says that is one of the cases. Also, two other cases, in re Adams, 215 Georgia App 372.
Well, 1 second. Give me the name of the first case again. In re what?
Do you want just the number, Judge?
Yeah, I would. Thank you.
215
215
Georgia App
Georgia App.
372.
Okay.
Also 215 Georgia App 349.
Okay.
That's Adams and Hasty.
All right. Let me take a look at those.
Bro, this how my mama talk good.
You have anything a little more current than 1994?
Hasty is 94. Unfortunately, contempt of attorneys is not a common proceeding, so most of the cases are a little bit older. But I do have other.
She talked too fast for Glanny. Not Glanny, Lee.
And Judge, I'm not the only one here. There's quite a few other lawyers that want to be present in the court. There's about 20, 25.
The challenge is I've got space allocations, as I told you.
All right,
So
look.
you can, like I said, since you are representing him, that's fine.
This when his pride started getting in the way because he had plenty of room to let all them lawyers in.
And we have to vet people to come in.
This when he
then they
started
can go
feeling
to
that
8H,
pressure.
and they can certainly watch the proceedings from there.
Okay. And Judge, for security purposes, they're all attorneys. They're all members of the bar. I can give you all their
They
names.
still would have to be searched and still would have to be subject to the court's protocol.
They got to
And
get
also,
searched.
there's room in the jury box, and then there's room in the courtroom. So we would ask that they be
I
allowed to.
don't want them in my jury box, okay? No.
I understand.
I understand, but we still finna give it to your ass, Judge.
May one additional attorney come in, then Alex Susser. And we're here on behalf of Gatchel for our strike force. He is
Well,
the chair
what's
of the strike
Susser?
force. I'm the president of.
Come on, Mr. Susser. Let's go, baby. Mr. Susser. See, when you got Trump lawyers on call like that, bro, you know you got pulled. You know you got pulled. That's why I always got shook up. Trump around here debating and stuff now, so she got time to come mess with us. YSL
Maybe
crew.
one I have too.
What's up, B? B done popped out. What's up, B? All right, come
As
on.
to
Get
how
y'all.
that information was disclosed.
Y'all talk.
That's a real problem. That's why it's of such, such an issue for the court at this point in time.
Judge, and Mr. Steele has a right to make a motion like this. If there were experts,
He does.
You see how when they talking with them hands? Okay, then ask. She done had hustle.
But he's kind of put himself in the particular position he's in.
No, Judge, I don't agree.
Y'all,
I
she
believe-
done had hustle.
Disagree with you, okay?
I believe that the court has put him in that position.
No.
He cannot
You
be
know,
held
white
in
women
hostage
talk
to
with their
McLaren,
hands
which I
like
cited to you
that.
earlier.
It is true that direct
Look at
summary
white
contempt,
KD.
which arises
Okay,
and
then,
spreads
white
the evidence,
KD.
penalize it, and or hinder, obstruct the orderly process of the administration of justice, the preservation of order and decorum of the court is exempt from due process requirements of notice and hearing. That's even Moody, goes back to 1974. So I believe that Mr. Steele's, he can file whatever motions, but his particular actions in this case, I just want to know who told him this. That's all. I'm not asking him to release or otherwise tell any conversations, but I just want him to tell me that.
And Judge, so that's what you want, but that does not conflate to a contempt. Your desire for him
Steele
to
was
answer your
trying to
question
get,
does not mean that you have the power to hold him in
So you
contempt.
can come into court, Mr. Merton, and not.
Look, Steele was trying to get Bumpus time to get out of town and all that. Like, I'm not telling you, Judge. I'm not telling you. I'm not telling you. I am shocked you're asking me. I'm not telling you this shit. Bumpus is supposed to be sneaking out. You remember she was at the airport. She said she was on the phone with her boyfriend, and then they heard her name being called, and she had the and that's why she came to court with her little outfit on. You know what I'm saying? So there was her excuse or whatever. But she still looked professional or whatever. She knew what she was doing. But still a real nigga, dog. Still a real nigga. He was trying to get her time to get out of there. Get out of here. You're fired. Your dusty ass fired,
Answer a
girl.
question of the court, not be held in contempt?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this is a question the court's permitted to ask.
And it's our position, if we had a hearing, we could explain to the court why he is not required. First of all, the court accused him of eavesdropping. That is a crime. He has a Fifth Amendment privilege against answering those questions. Rule 1.6 protects all confidential information that is gained, not from your client, but in representation. He has the ability to protect that information. But we don't even need to get there because he can't be held in contempt, and you can't threaten him with contempt for presenting a motion in good faith. He presented a motion in good faith that he believed there were ex parte communications. You are a witness to that because it's my understanding that you were part of those ex parte communications. They can't be ex parte if you weren't part of them by nature.
Okay, well,
You have to be involved. Therefore, you have to be a witness. So you are a witness. You cannot also.
but you got the information. But here's the thing:
standing
you
on
got the information allegedly from an improper methodology. I'm not saying that he eavesdropped. Okay, I said that one of the things is it's either one of two ways. He either eavesdropped, which I don't believe he did at all. I don't believe that for a minute. But I do believe that somebody did tell him what was the sum and substance of the court's conversations, and that would not be permissible.
Judge, let's just back up for a second. He makes a motion because he has reason to believe that there were ex parte communications made. The court has a duty, if there are ex parte communications made, to alert counsel. He shouldn't have had to learn it from wherever he learned it.
I think that he caused that particular circumstance. I think that he had a conversation with somebody and he got some information that he shouldn't have had to begin with. So, Ms. Merchant, I'm of the opinion I'm going to stand on my ruling at this point in time. I'm going to hold him in contempt. So at this point in time, is there anything else you want to tell me?
Yes, Judge, there's quite a few other things. So first of all, we would ask for you to be recused from this case because you are a witness necessarily. It cannot be an ex parte proceeding without you being a witness to this.
When you call a judge a chief witness, that's like calling him pussy to his face. You know what I'm saying? Like, them folks do not like to be called witnesses. That's why he's looking down right now. And that's why her comeback was, you are now a witness. He looking down and shit over there, farting and shit. Looking at Jack ready to kick his ass.
So
oh,
Jack.
Let's send a prayer for Jack.
To the contempt. You are a witness to the contempt. So you have
What
now,
a
and if it's criminal, which is what you're saying it is, Mr. Steele is entitled to all the same due process rights that Mr. Williams and every other defendant in this courtroom is entitled to. He's entitled to those. One of those is to have a fair and neutral judge decide his case. One of those is to have a judge who is not also a witness in the proceeding deciding whether or not he's in contempt. This needs to be heard by a different judge. And he has the right to subpoena witnesses. He has the right to an attorney. He has the right to due process, notice, a show cause hearing, notice of the alleged violation, whatever rule it is that the court believes, and a hearing where he can call you as a witness. You can testify. You are necessarily a witness. You can't, for it to be ex parte, you have to be a witness. It can't be both ways.
I'll let an appellate court decide that. So, anything else?
No, we'll file a notice of appeal.
You know what a nigga wrong, I'll let the appellate court decide that. What? What, nigga?
Okay.
And we need to have the order reduced in writing as well.
I'm going to do that right now. I will say for the record at this point in time that Mr. Steele has in fact, or has filed, and I will note this as part for the record in this case. He's filed a motion to set aside the contempt. He's filed a motion for a supersedious bond, and he's filed a notice of appeal, all of which I will include as the next court's exhibit in order. But I'm reducing the contempt to writing. And I mentioned earlier, he can purge himself of the contempt just by telling me who it was, and he can do that this evening. He can do it right now. He can do it at any point in time. If not, I'll revisit the circumstance on Friday.
And Judge, we would ask that you grant the bond. At this point, grant him a bond on that issue.
You don't get a supersedious bond on a criminal contempt, though.
You can grant him a bond.
No, you don't get one on.
You can grant him a bond.
Is the one that you can hold him until
you can grant him a bond, bro.
I'm sorry. I think in
Just the case law on that is in Ray.
hold on.
Right.
Get that man a bond. Give him a bond.
The superseded bond requirement does not apply in a contempt in the presence of the court during the progress of a proceeding, OCGA 5-6-13 Bravo. So you don't get a supersedious on that.
Hey, y'all got a question. Who y'all think is worse, Tick, Woody, or Adrian Bean? And who y'all think is smarter, Tick, Woody, or Adrian Bean? I want who is worse. I want who is funnier, and I want who is the smartest out of them three. Who? Tick, Woody, Adrian Bean.
On a criminal contempt, respectfully.
So Judge, just to clarify, it's your ruling that this is a criminal contempt that Mr. Steele has committed, not a civil indirect contempt.
That's correct.
The judge, that's the reason I'm asking is because the N. Ray Hughes case, which is a 2009 Court of Appeals case, 268, Georgia Appeals 66, lays out the distinction, as does the Ramirez case.
There's a case that, in fact, is, I do one better, sir. In fact, there is a recent pronouncement out of our appellate courts.
Which is, I think I'm addressing a slightly different point of law.
It is, hold on. One second. I think the two cases, one is, it's Untema, it's a UNTEMA versus Smith, and that's 371 Georgia Appeals 19.
All right, look at this. Look what she said. Tick funny, Woody smarter, Bean a snitch. But y'all remember, Bean is the oldest one out of them. He only snitched because he was talking to his wife. He never talked to the interrogators. Woody is more of a snitch than Bean. Is that not right? I'm gonna agree. Look, Tick the smartest and funny. Woody funny too, though. I think Woody the funniest, Tick the smartest, and I think Adrian Bean is the worst. Like all that I don't recall shit and all that. Like, see, look, Bean was the worst. Woody smarter. Tick was funny also. See, you rule with KD. See, I think Bean was the worst. Woody is the funny one, and Tick was the smart one. I think Tick the smart one. You know what? You want me to know? You want to know why Tick the smart one? He was able to come up with why YSL was something else on the spot. Ain't nobody from back in the day can come up with the acronyms right on the spot. I think all them other niggas would have said something crazy. Tick is the smartest. He knew them. Yeah, he knew them called. Tick never snitched. He took the plea deal though. KD, he took the plea deal though. He snitched. Tick snitched because he said there was a game. He snitched. If Gunna is a snitch, if Gunna is a snitch, not KD is a snitch. KD, hold on, KD, is you a snitch, KD? Hold on, but if Tick is a snitch, Woody's definitely a snitch. Adrian Bean definitely a snitch. But if Adrian Bean and all them are snitch, Tick snitch. If Woody snitch, Tick snitch. Tick snitch. I mean, if Gunna snitch, that's what I want to say. Gunna. If Gunna snitch, Tick snitch. If Gunna snitch, Tick snitch. That's a little you can't say this shit 5 times fast. If Gunna snitch, Tick. If Gunna snitch, Tick. Hey, I was gonna be petty. I was gonna sing y'all something. If y'all could say if Gunna snitch, Tick. If Gunna snitch, Tick stitch. If you could say that 5 times, I'll send you $100 right now. Say it 5 times fast without messing up. If you could say that 5 times without messing up, I'll send you 100. If Tick snitched, what's called snitch? If Tick snitched, Gunna snitch. If you can say that fast 5 times, I'll send you 100. Oh, I know ain't nobody say Tasha correct. Okay, so now KD is snitch. That is snitching. Oh, you never said Gunner's on a snitch. Being in the gang is not. No, this is why I say Gunner snitch. Gunner snitch because he said that was not my drugs. I was in a car with Jeffrey Williams. YSL is a gang. Like, that's snitching. That's snitching. Listen, y'all can't ignore though the fact that I ain't even say it right, Lee. Y'all can't ignore the fact that that Lil Baby and all the whole industry think Gunna snitch. There's some behind us, like he has their label now, y'all. When he went to the BT Awards, what the first thing they asked him? Gunna, did you snitch? He said, hey, give me my notes.
Which was decided March the 12th of this year. It covers the differences between.
KD, don't type in capital
And
letters
then
no more.
there's another
Keep it
case that I
professional.
invite your attention
I think
to,
you yelling when you
and that
type
is
in capital
Henry,
letters.
Syverston. It's Syverton.
It's not illegal, but it is illegal.
368 Georgia
Look,
Appeals.
let me say, look.
Georgia app, I should say 860.
I think Gunna snitched when he said, you remember when Gunna and Thug got pulled over? They got caught with certain shit in the car. Gunna said, it ain't mine. He was supposed to keep it solid. He was supposed to keep it solid. So we can say that YSL is a gang. I give him that. But when he said, that ain't mine, that Jeffrey Williams, that's his shit. Who else? Because, you know, after they asked what was in the car, he's told them what was in the car. Then they said, was it yours? He said, no, it's not mine. And then they asked him, who else was in the car with you? KD. Oh, okay then. Okay.
5, and that was decided July 31st of last year.
And Judge, I'd just like to point two things out. The statute that you were citing about the supersedious, it only says it's not mandatory. You still have discretion to grant him a supersedious bond. The other,
I'm not going to grant a supersedious.
and so you definitely have the discretion to grant him a supersedious bond. The other issue is if it is a criminal contempt and you are finding him guilty of criminal contempt, then we have to have a sentence imposed. Now, civil is where you get to hold him until he complies.
No,
criminal is where you get to impose a sentence, maximum 20 days and $1,000 fine. So if you're going to incarcerate him under a criminal contempt, he's got to be sentenced.
Well, his contempt is as long as he when he tells me what the basis of the
Yeah, right. In what car, KD?
What?
In what car? What you talking about?
Certainly, he purges himself of the contempt.
Then that's civil, Judge.
That's civil contempt.
That's civil.
And that's respectfully, I would point you to In Re Hughes, which stands for the same point of law. Civil contempt impose punishment as a means of coercing future compliance with the prior order of the court. Here, the prior order of the court presumably is that you have directed Mr. Steele to answer the question, to disclose the information as to who is his source for knowledge of this ex parte meeting that occurred earlier today. Criminal contempt imposes unconditional punishment to punish the act which has occurred in the past and cannot be purged. It is not capable of being purged, in which case what Ms. Merchant said applies, which is that there is a 20-day maximum sentence and $1,000 fine. It is, for all intents and purposes, a misdemeanor offense.
Hold on, let's pause. Mr. Long Ponytail. I don't know who he looked like. He looked like somebody I know with a long ponytail. Hold on. It was 3 people in the car with Gunna and Thug. Hold on. Now she. Vito man was the 3rd person. I didn't know that. I thought it was 2 people. So why Vito ain't on camera saying what happened in the car? KD, who else was in the car with y'all? Why Vito ain't say what Gunna said? Why we ain't got no recording of what Vito said? Oh, I'm gonna show y'all something too. Cause people talking about do y'all think it was a secret recording when Gunna was filmed in court? Was it secret or was they supposed to film like what they doing now? Tell me that. Was it a secret when Gunna got filmed? Was it a secret or was it not a secret? Were they just allowed to film or was it a secret? Somebody tell me now. Sierra, you better not. Hey, Sierra, I gave you a shout out last night. Nurse, tell her what's up. They were allowed to. All right, I'm gonna leave it alone. I'm leaving it alone. We're gonna finish hearing Ashley Black self. Here we go again.
Why the enhanced due process protections apply to that. Now, Mr. Steele has indicated to us he does not believe that he can answer that question without violating his duty of loyalty and duty of confidentiality to his clients. So he is being placed in a position where he's either going to jail or he's going to commit an offense that will put his license to practice law at risk. And that is an untenable position to be in. And Mr. Steele is a zealous advocate for his client, and he is simply trying to protect that duty of loyalty and duty of confidentiality, because if he answers your question, it is very reasonable to assume and likely that he will be facing a bar complaint that could result in a suspension or in the loss of his license. And so he's in a very, very difficult position where if we were able to have a full contested hearing with the benefit of witnesses and an impartial judge where you're a witness, then everybody could present their side of the story. And
I'm not doing that. The reason being is because that takes away the whole
I said I'm not doing that.
Contempt, and that is you do something, the court tells you to do something, order of the court, and you don't follow it. I didn't ask him to do anything illegal, immoral, unethical. I just asked him to tell me. I know what the privilege is. The privilege is
Ashley got a big back.
Ask him about
big back.
the person. Because
Mr. Steele has indicated to us that he does not believe he can answer that question without also violating the privilege.
Okay.
And Judge, that's why we're trying to figure out if it's criminal versus civil. So the issue is you're picking and choosing. You're saying, well, you get the bad side of criminal and no bond, but I really am actually trying to punish you civilly, which is when you hold someone until they comply.
Okay, let me think about it just a second, okay? I'm gonna take 5 minutes out and we'll think about it.
Thank you.
Okay, all right.
Hey, Bree, I got that from Bree. Ever since Bree said big back, you have to be dying. All right, so they did that. They got the arguing. Then they're gonna come back. I'm playing KD live after this when we did the transcript. We're gonna listen to the transcript after this. KD, send it to me in Discord. You know, I don't really know how to move around like that just yet.
Can I ask a question?
Sure.
I'm going to file notice of appeal, but for whatever reason that doesn't take.
Hold on.
Mr. Steele, if I could ask you to take the podium,
I gotta walk up
as well.
This one come up now. How Steele become a defendant in his own, you know what I'm saying, case where he got his own defendant. Steele walk up, he get in the middle. They little boy him rubbing on the back.
Mr. Steele, and I apologize.
Oh man.
Mr. Susar.
Oh man.
Susar.
What spell your last name for us?
SUSOR. Sierra, uniform, Sierra, Oscar.
You're a good man. Good man. Okay. All right. Okay. All right. Thank you, sir. Okay, Mr. Susar as well. All right, counsels, I've made a clarification or to the order of contempt. Mr. Steele, I am going to hold you hold you in summary criminal contempt pursuant to OCGA 15-1-3, subpart 3, for your failure to comply with my earlier order today. I'm going to order that you be taken into custody, incarcerated in the Fulton County Jail for no more than 20 days for this contempt. Those 20 days consisting of every weekend for the next 10 weekends. And you'll be reporting to 901 Wright Street Northwest, Atlanta, Georgia, 30318 at 7 p.m. on Fridays. You'll be released on 7 p.m. on Sundays. And it's to commence this Friday, June the 14th at 7 p.m. and not to end until Sunday, August the 18th at 2024, 7 p.m., subject to further order of this court. And that will be entered and e-filed. You may take whatever steps you and your counsel deem appropriate after that. Okay?
Can I ask a question?
Sure.
I'm going to file notice of appeal, but for whatever reason that doesn't take, and you don't give a bond, then I'd ask that I can be with Mr. Williams and we work on our case all weekend, for all those weekends. Otherwise, I can't prepare. I speak with Mr. Williams all the time.
That's up to you. And sir, I will, if that comes to pass, you have my my support. I will talk with our sheriff and we may be able to make that work. Okay. If that should occur. Okay. All right. Okay. All right. All right. Is Miss counsels, I'm done with this unless you have anything else. All right. Thank you. Thank you, Miss. Thank you, Miss Merchant and Mr. Susar.
Thank you.
Okay. All right.
May we get a copy of that?
Yes. In fact, the clerk is going to file a copy. It's going to be e-filed. It'll be on the e-file system momentarily.
Y'all, I got 3 or 4 iPads. I'm gonna go get them in a minute. But I got like 3 or 4 iPads. I'm a electronics geek. I love having shit, electronics and shit. Hold on, KD. We finna go to KD live and listen to this transcript real quick. It ain't boring, so we'll be straight. We'll be able to talk our mess while we listen to it. You know what I'm saying? KD did her thing. We had fun over there. Finna go to KD. I ain't gonna lie, since KD name is KD, anytime you type KD, you see KD. You gotta type something like KD transcript. As soon as I click on it, I heard nurse talking. All right, we gonna start in the middle of, like, we ain't gonna start at the very beginning. I'm gonna start where it get, you know what I'm saying, spicy. Hold on, y'all. The ex parte. Send me one, please. Hold on, I got you. Hold on. My girl KD live. Hey, we was over there turned though. KD did her thing on this joint. I hate she got it pink, but we ain't gonna discuss that right now. We're gonna put our grievances in the file box later on. Apologize.
In writing, it's not.
But this the transcript we was reading over there. We can listen to this real quick.
Has nothing to
Yeah,
do
we
with the
gonna chop you
exposure
up.
from this state. And if his concern,
His being whose concern?
if you look at it, it looks like some stuff was left out.
Tell me when y'all want me to pause or if anywhere.
She's making it seem like he's more concerned about
listen to what this bullshit.
Thug now. Am I right?
It looks like it, because unless he cut her off.
Some stuff looks redacted.
I do.
And now who's the judge? Because the judge needs to speak.
Did y'all hear me? I did. I said his being whose concern. Okay.
Okay. Okay. Mr. Melnick, if the interest is he is protecting Mr. Copeland's freedom, he did not convey it by asking us what exposure does he face in testifying. In fact, if he's concerned that testifying will get Mr. Copeland killed and he is not communicating with us, he's communicating with counsel for the defendants. It would seem that he knows a thing or something that we don't know. Additionally, and I will let Ms. Bumpus tell you, he has said if Mr. Copeland testifies, he's no longer representing Mr. Copeland, which is strange because if you're interested, your client, then it would seem you would want to be there for him while he's testifying.
Well, he is on vacation this week.
I understand. That is why he has Ms. Bumpus here. And he has said that, and he has said what he said. And as I was reading the statute.
In the transcript that we read, what y'all think was left out? Like, because everybody kept pausing. Like, what y'all think was left out? Do y'all, or if any? Because everybody say Woody said something was, yeah, this is my favorite transcript right here. We did that.
The thing that is, and I was reading the statute about this particular situation, and I was reading our rules, our ethics rules of conduct for attorneys, and it is clear that if an attorney, there are 2 things that were happening. One, Mr. Melnick had told me that he wasn't Mr. Copeland's lawyer. Mr. Copeland had told Ms. Hilton that Mr. Melnick wasn't representing him. And then rather than Mr. Copeland reaching out to Mr. Melnick apparently was in communication with Mr. Steele and Mr. Sharp. And Mr. Melnick reaches out to Mr. Copeland and injects himself in these proceedings. What we're discussing was in no way a matter that Mr. Melnick was representing Mr. Copeland on. And that is where we are not allowed to speak with a person when they are represented by counsel. Mr. Melnick could not have been representing Mr. Copeland on anything we were talking about because we were talking about this case in this trial. All that aside, we would like an opportunity for the court to address Mr. Copeland with Mr. Copeland's stand-in Council President. Miss Bumpus is looking at me like, bitch, you nasty hoe. Okay.
Hold on, we ain't got Miss Bumpus up here.
We ain't got no Miss Bumpus.
Now who gonna be Miss Bumpus?
We doing dual roles? You want me to say? I'll be her.
Okay.
Okay. I'm listening.
With his standing council present, and to allow Ms. Bumpers an opportunity to explain to Mr. Copeland everything that I have said. Her concern outside of what is the longest he can stay in jail. What I can say to her is the statute here, the statute says until he purges.
By testifying.
His contempt is testifying.
Yeah, 507 is a little bit different. So, I mean, so until the end of this, a leave filed since December.
We have nothing to do with any of that. He injected himself into this.
Yeah, see, the problem is
we stepped in.
That when you get involved, I don't know you have a leave.
Right, you.
And unless you file that leave into this case, you don't have a leave for my case.
Right.
Okay.
And he did not.
So he didn't have one?
Mr. Copeland's been a witness and a name on this case and a name on this witness list since.
So since he said, well, I represent him, I'm like, okay, well, you don't have a leave that's filed in our case. Okay.
So he did this to himself and he did it to you. But we have to, that it's just where it is. And I don't know that. That's just where we are.
So, Judge, you are going to make me stay if he chooses to testify? I am, because you're his lawyer. You're his lawyer. You're a stand-in lawyer at this point. Your Honor, I don't have a problem with that. I'm not ready.
If
there's nothing for you to be ready about. I mean, here's the thing. I think the only thing you got to kind of ask him about is, look, here's the questions the state is going to ask you. All right. Is there anything else that could hurt you that they might ask you about? And as long as you have knowledge of that, then I think that you are fine, because the state's only going to get into this. Now, the reason you want to know what's going to hurt you is the defendants know more about Kendall Copeland than anybody else. So they are probably going to kind of, well, what about if I say I can't do it then? Then Melnick needs to come back, right? Am I going to be in trouble? Because I was only for Monday. That's what I was told. I was given specific.
If Copeland said, I don't know what Mr. Copeland wants, is his choice.
Can he say he doesn't want Melnick?
He can say whatever he wants. It's his choice.
But the judge is saying,
I don't think he can be forced to have representation if he doesn't need, or say he wants it, because we have offered. We have done everything to clear him of judicial exposure.
Hold on, look.
He's not. There is nothing.
What y'all think about in this transcript before Woody come in, before I come in, Miss Love, she wasn't in the transcript no more. Do y'all think that she left somehow? Like, what happened with that? Miss Love disappeared. What was going on with that? How Miss Love disappeared after this transcript eventually when Woody show up towards the end. I'm gonna skip it in a minute, but I want to let y'all notice how Miss Love and Miss Bumpus went at it for a minute, even though Bumpus said she friends with Hilton. Hilton was somewhere else talking to Woody, and Bumpus was talking to Love, even though Bumpus and Hilton the ones who friends and shit like that. And how Miss Love disappeared when Woody show up. What y'all think about that?
Nothing he can say. He could lie. That puts him in,
peril.
That's it, ho. But he can't talk about a crime that we could then prosecute him for.
That is involving this or some other place.
Right.
I understand that, but.
And we can't use his testimony to go find evidence to prosecute him for the stuff he talks about. Basically, he is literally shielded.
I would have to agree with you, but I don't think that's a concern. Isn't that what you said?
Well, the court said that.
No, I'm saying with Mr. Copeland not testifying, you said you don't think that his concern is criminal exposure, or do you think that it is what he's worried about? Do you think that he's fearful of testifying for other reasons, like for personal safety? Right.
This is what Mr. Melnick said to me in the email. I can pull up. He said,
but you don't believe that.
Would y'all rather me skip to the part where Woody show up too? I'm gonna skip to where Woody showed up because we can play with it at this point. Woody showed up around. It wasn't that far. It wasn't that into onto it. Hold on. All right, Woody showed up around now.
This may ask you because they may know your business, but if they ask you about things that you might think you might have some liability with, you can't be prosecuted for any of those.
Bro, I got family members watching this shit, bro. I don't want my nephews and shit thinking this, hearing this shit, thinking this shit cool.
But I think that's a separate conversation you can have with them as an honest individual. Like, look, nephews, I done lived a life I don't want you to live. Don't go through what I've been through. But that's something you can have outside of being in jail, because that's better. That's a better conversation you can have with your nephews in person. But they shouldn't have to come to DeKalb County jail because you are being held in contempt. You can have the conversation with your nephews tomorrow in person. You can't have that conversation with them. You can have that conversation with anybody. You don't know what's coming up this weekend. Why are we in jail? What are we doing?
But y'all did this shit intentionally.
No, we did not. You and I had this conversation, Mr. Copeland, on Friday morning.
Hold on, Dusty Ho. You knew my child's birthday was next week. I knocked your ass out.
But what did I tell you when we met with each other? I said, you asked me, what is the one thing that's going to get me in jail? Didn't you ask me that? And what was my response? If you plead the fifth, and that's exactly what you did on the stand.
But what did I tell your bitch ass before I got to that point? I told you the whole time Tuesday, Wednesday, Thursday.
But I told you we were giving you immunity.
That I was pleading the motherfucking fifth.
No, you did not.
Bro, I told you every day I was pleading the fifth.
No, you did not. And we told you.
I told you my concern.
And we said we could give you immunity, motherfucker. You said your concerns is what they know about you. And when you said that, I said, well, you know stuff about them. And then I said, whatever your concerns are, we can give you immunity.
So I ain't tell your dumb ass that I lied on them to get myself out the situation.
You said you were a liar. That's what you said. You said you were a liar.
Wait, was this recorded?
No.
Of course not. And did he ever say that Melnick was his attorney?
No, this week, when we first met you in the car on Friday, we asked you, is Mr. Melnick your attorney? You said he's not my attorney, and I haven't even talked to him.
You lying bitch! I never said he's not my attorney. I said that I ain't talked to the nigga. Bitch, you lying.
You said he's not your attorney. You haven't talked to him. Then we continue to have this conversation. At no point did you ever say, hey, I want Mr. Melnick here. Hey, put Mr. Melnick on the phone.
Bro, you didn't make me feel like I needed the nigga.
But if you needed him, would have said, if you would have needed Mr. Melnick, we would have said to you, okay, just call him. Oh, so I mean, this is our position. We don't want you in jail. We just want to be able to purge yourself by testifying. Whatever your truth is what your truth is. But you just got to answer the questions. Please. We believe that whatever your truth is what your truth is. We know what you said before. I don't know what you're going to say on the stand. I hope you would tell me what I want you to tell me. But we know is pleading the fifth is going to keep you in custody. That's what I know. Now, how you answer your questions is how you answer your questions. I know what you said before, nigga, and I know what you said later.
He called me a nigga.
I know what you said before, and I don't know what you're going to say on the stand because you and I never went into full details about any of this. But what I don't want is you to be sitting here in custody.
Bitch, you fucking did it.
I did not do it. You did it by pleading the fifth.
Bruh, you told me so funky breath ass, so ashy feet ass before you went to the judge with whatever the hell the thing you called you went to him with. You told me that I can't, when I'm asked a question, I can't say I don't recall or I don't know. You told me that shit. That if I plead the fifth, I mean something. Why would I plead the fifth to? Why would I plead the fifth to something if I ain't do it? And I said that you don't know what I did and what I ain't do. And then you was like something. And then y'all asked for this immunity shit. And I was like, what the fuck? It was something. And then Friday, Thursday or Friday came, and then y'all go tell me, oh, we went to the judge with this, so you gotta testify. If you don't testify, the judge gonna lock your ass up.
Right, but that was based upon you.
But I told y'all that.
No, you didn't.
All right, ho. You said, why would I plead the fifth for something to do something I didn't do? And I said, you don't know what the fuck happened.
And I said, I don't know what happened. Only you and them know. I said, but you never said, I'm pleading the fifth. You said, what if I do this? What if I do this? What if I do this?
I told your bitch ass, I said, I'm going to plead to the, your ugly ass cut me off, and you said, why would you plead the fifth to something that you know you didn't do?
So if you didn't have immunity prior to, is that what you were saying? That you feel like he didn't have immunity prior to?
Nigga, immunity came Friday, right when I went to jail.
The immunity only came after Mr. Melnick.
Hold on.
The immunity came after Mr. Melnick sent us an email saying my client is pleading fifth. That was on Thursday evening at 6 p.m.
Okay, that makes a little bit more sense.
So after that, that was an empathetic, he's pleading the fifth.
Oh,
We came and we got this signed. And then Friday morning came.
Okay.
So between Friday evening, Mr. Melnick reached out to us and said he represents him and he's pleading the fifth.
Okay. And when was the last time you talked to him before Melnick got involved?
We talked to him early that day on Thursday.
Okay. And then how did...
Bro, he called me, bro.
Okay. I was just trying to get a timeline. Calm down.
Sure, right. So we've been talking to him since last Friday. So I met with Mr. Copeland last Friday. I was out in the neighborhood. Then he came Tuesday for court. We talked briefly on Tuesday. And then Wednesday he came.
Bitch, it was Thursday.
No, I think he only came 2 days. So it would have had to been Wednesday and Thursday he came. It wasn't Tuesday. It was Wednesday and Thursday he came. And then on Thursday, once we left, is when Mr. Melnick reached out to us and said, my client is pleading the fifth. And at that point is when we went to the next morning and got the immunity motion. And then we spoke on Friday morning. I handed Mr. Copeland this agreement and let him know that he has immunity and that anything he can't use. And then Mr. Melnick came and then we had court.
So you pretty much saying you didn't ask for this?
Hell no, that bitch lying.
But we gave it. He doesn't have to ask for it.
I know. I mean, he's just saying.
Right. He doesn't have to ask for it. But to alleviate whatever his concerns were, we gave him immunity. He didn't have to ask for it.
So if he wouldn't have had this, I'm just saying this so he can understand it, because you know he's a little slow. I'm walking him through. Would he still have to testify, or would he have been able to plead the fifth? That's what he's saying.
If he did not have immunity,
Yes.
yes, he could plead the fifth.
That's what the fuck I'm gonna do, fool.
Yeah, that's what he's trying to say. He's trying to say that he didn't ask for any of this.
But he doesn't have to ask for it. Now that we have given it to him, because that's on us. So now that we have given it to him, it's an order. He can still choose if this is the road he wants to take. Then he'll just stay in custody until the trial is over. And when we say the trial is over, every last defendant has been tried. Not just these 6, the other ones too.
Oh, you might not know. I'm Big Woody. I done did longer time than this shit, bitch.
All right, Mr. Copeland, I'm telling you that you're literally immune from prosecution for anything else you may say.
I'm Big
That's
Woody.
that.
I'm Big
So
Woody
choice is
around here.
always
What's wrong
up
with
to you.
y'all? Don't
But we
call me
wanted
Lil
to
Woody.
put on the record that the state doesn't want you in custody. What the state would like you to do is purge yourself from,
What that shit mean?
meaning that you are no longer in custody. The way that you purge yourself is to testify. That is kind of how it happens. And that is what the state wants you to do. We don't want you in custody. I can't say that any other different ways, but we don't want you in custody. The only thing that is holding you is you refusing to testify.
So, do you have any questions? Any other questions? Basically, if you invoke the fifth,
Bruh, I don't trust this bitch. I don't know what's going on. I don't trust nobody in this bitch. I trust her word, but I don't know what's going on, Your Honor.
This is your insurance. I don't know if you want to break that down to him.
well, he doesn't want that. But he's been given it. See, that's the challenge. Mr. Copeland already slow. Is that if they didn't give you immunity, you could invoke your Fifth Amendment privilege. But what the state decided is that they said your testimony is worth more to them at this point in time, and they really, really want to know what you have to say. So they from the state's perspective, they have made a decision to give you immunity, so you no longer can invoke your Fifth Amendment privilege. You have to testify. So that's the difference in this particular scenario, is that they have taken away, well, you can still invoke your Fifth Amendment privilege. You still can do that, but the consequence of invoking it is you will just remain in custody. So if you testify, you get out of custody. And you stay out of custody until you're done.
And then if I don't testify, how the fuck long do I have to stay?
Well, until the trial is over. Matter of fact, until all the defendants have been. I got these 6 that we have right now, and then there's another 6.
No, actually, there are another 12.
Oh, there's another 12 or thereabouts that are still outstanding in various forms.
Hold on. Let me go talk to this little freaky bitch in the corner.
Yeah, sure.
Sure.
All right, my question is, I can ask you a question.
Sure.
My question is, so what I was asking her was, if you asked me a question and you feel as in I was lying about it, you will lock me back up?
No, if you're saying you say I didn't talk to Demikion. Well, no, I can't talk about that because the judge is in here. You are asking for example. If you said before the sky was blue, and I asked you on the stand what color is the sky, and you said it was red, I'm going to say no. Back before you said it was blue. Is that what you're trying to ask me, y'all? Before we keep going, y'all remember he said that on the stand to her. Just want to throw that out there.
Dang, I don't remember. Oh yeah, that's when you start talking about them Chuck Taylors and the white shoes. Yep.
Mm-hmm.
She said they white diapers.
So explain the independent evidence. If he says he did something and you know he's not telling the truth, then what happens?
If he says something, he did something. He did not do that thing.
If you believe he did not, so if you believe that he's lying about that,
then no. If he admits to doing something on the stand,
uh-huh,
and he did not do that thing,
uh-huh,
I'm going to say, is this the first time you're saying that?
and you have independent evidence to prove it wasn't him, huh? Then what?
Then nothing. What do you mean? Like,
So then he will be fine?
yes, but
so you are okay with him if he got on the stand and said things that weren't true?
no, I want him to tell the truth. What have I always said to you? I want you to tell the truth. I don't know what's going to come out of your mouth. I expect you to tell the truth. If you say something that is inconsistent with what you said before, then I'm going to ask you about those inconsistencies. But I expect you to tell the truth. What you're going on the stand, what you go on the stand and do, I don't know. I don't know what you're going to do. I want to tell the truth. I want you to tell the truth, sorry. I will deal with you, not. You're saying something different in the manner that I normally do.
If I'm saying something different, right? So when the police question me, they been questioning me every time they lock me up. I don't know. I don't know how many fucking times there was. I done told them whatever the fuck different story I could think of to try to finesse my way out of the fucking situation. I don't recall shit. Shit!
Okay, so oh my bad.
Sorry. Okay, so you can say I don't recall. That's how that works. I don't recall.
And he can say that to every single question?
I would hope that that is not true. The truth. Because I think there are some things that he may recall and some things that you don't recall. And then I will go through my process of what I do. You can't talk to him about what impeachment is. That won't get you locked up. Impeachment will not get you locked up. You can talk to him about what impeachment is. If he says, I don't recall.
Bitch! What will get me locked up?
What did I tell you?
Oh, I don't know.
What did I tell you on Friday? I pled the fifth. If the court instructs you.
So the only damn thing that can get me locked up is pleading the fifth?
Yes, nigga.
The court instructs you. You need to answer the questions. You
Well,
say
damn.
again, I plead the fifth. Again, that's what's going to get you locked up. But if you answer the question, that will not get you locked up.
Bitch. So if you don't want me to go to jail, why you just don't let me go after the trial over with?
You are in jail because you are not answering my fucking questions.
Oh, this man is slow. Because you have been given immunity.
Because you have been given immunity, you are only in jail because you got up here.
Okay, how about this funky booty ass hairy chest bastard? I answer the questions, you take away the immunity, I answer the questions, and I plead the motherfucking fifth.
No.
He was trying to plead the fifth
To
the
the
whole
questions
time.
that I feel incriminate me.
But then that's.
I won't plead the fifth for things that don't incriminate me.
The state can still give you immunity. They can give you immunity to whoever they want. Okay. And they can make their choice. I don't even make that choice. So if they, like I said earlier, they want your testimony, they figure it's that the jury needs to hear what you have to say, good, bad, or indifferent. And that Miss Hilton is telling you is just tell the truth as you know it and let her worry about it. I mean, even though you may have said different versions of whatever, that's for impeachment. That's not going to get you in trouble. But what will get you in trouble is you just invoking your Fifth Amendment privilege because you have been given immunity. Or as Miss Lion Love said this morning, remember, Lion Love said if you overtly lie about something, like if you tell a bold-faced whopper, then they can indict you on that particular charge. I mean, that particular false statement.
Bro, that's what they gonna do, bro.
And that is what I was trying to tell you. You're gonna be right back here.
But if you say something that you know you did not do, like you admit to something you know you didn't do, whether you
Like murder don't have like no statute of limitations, right?
but if you didn't do it, I can't charge you with something you didn't do because I don't have any other evidence but you saying it.
But y'all don't like
You can charge him with false statements and he will be back in jail. That is what I'm trying to say.
But if I know that you're lying about that, I do not intend to do that. If I know right now he's lying, I know he's lying. I'm not going to charge you because I don't know your reasoning for doing that. But I'm not going to charge you when I know you didn't do what you're trying to say you did now. And that can be part of this. I know you didn't do it.
but it's up to the judge to do that, right?
No, it's up to the state to bring charges.
I don't have anything to do with it.
He has nothing to do with bringing charges. That's up to the state of Georgia.
Can I talk to my family and I will make my decision right after I hang up the phone?
He's saying he hasn't been able to speak to nobody.
His sister just called us. She
Well, y'all bitch ass nigga doing me wrong, bro. Y'all just hold me in jail. Don't let a nigga pin it up. No nothing, bitch.
we had no knowledge. We didn't know that you.
He hasn't been able to do anything, speak to anyone.
Damn, but y'all put people in.
That part I didn't know. I know we had been in communication with your sister. Your sister actually texted Miss. Ooh, I can't think of it. What the Miss Les Quad. Baby, I'm finna have a Sylvia moment to make sure you're okay. It looks like Lens Quad. To make sure you were okay. We told her we physically laid eyes on you. I'll leave that up to the sheriffs. I don't know.
So what you think she was talking? So what you think what she was talking? What you think what she's saying?
I can tell you right now.
I'm talking about the locking me back up part.
We will have to bring charges. There will be no incentive.
Come on now, you know y'all bitch ass will.
We've already had this discussion.
Look what you did to me. You waited until Friday and did this shit. I done told your dusty ass every day before Friday that I came that I was pleading the motherfucking filth.
No, you didn't. As a matter of fact, our last.
Mr. Copeland, let's see if we can get beyond this, okay? Because what the concern is, you could have invoked the Fifth Amendment privilege. The state could have turned around and said, stop, had me, go ahead and file the motion and give you immunity. It was going to, they make that decision. They decided to make it on Friday. So even if you would have been more comfortable testifying and invoking your Fifth Amendment privilege, they could decide you as a witness and want your testimony more than they do you invoking your Fifth Amendment privilege. So they gave you immunity. They gave you immunity, so you got to testify truthfully as to what your knowledge of the particular incident is. So they could have done that anyway. Even if they put you on the stand, they could have said stop and gone ahead and given you immunity. They could have done that.
So can I get some type of writing that if I was to testify that if she feels that you're not lying about anything that won't lock me up, that they won't lock me back up?
Let me have that, Ms. Bumpus. Mr. Copeland, on page 2 of the order pursuant to OCGA 24-5-507. However, no testimony given by Kenneth Copeland as required under this order or any information directly or indirectly derived from the testimony of Kenneth Copeland given by Kenneth Copeland as required under this order shall be used against said Kenneth Copeland in any proceeding or prosecution for a crime or offense concerning which he testifies under this order. Okay? So you testify about some aggravated assault or murder. They can't prosecute you on it because that is what it says on the order. Okay? The only thing that will get you in trouble is this next little paragraph. So I want you to pay close attention. Kenneth Copeland shall be subject to prosecution or to penalty or forfeiture for any perjury, false swearing, or contempt committed in testifying or failing to testify in accordance with this order. However, it is ordered that Kenneth Copeland shall not be required to produce evidence that can be used in any other court in the state, the United States, or any other state. So basically, if you commit perjury, false swearing, or contempt committed in testifying, that means if you just invoke your Fifth Amendment privilege or failing to testify, you say, I'm not going to testify. All right, bet. So the only two real things you can kind of get in trouble for are perjury and false swearing, as long as you tell the truth. Now, as for Horrible Hilton and Ms. Bumpus said earlier, you may have told or been asked about situations over and over and over again. They may have changed, but what the state is asking you to do is tell the version that really is the truth. So if they want to impeach you, they can do that. Or if the other side wants to impeach you, they can do that. You won't get in trouble for that.
Hold on. You saying I will?
You will not. You will not. Impeachment is not perjury or false swearing, okay?
Okay, but she just said I could purge myself though.
What Hilton it?
Funky Booty Hilton.
I'm sitting up here talking, y'all, and y'all can't hear me. No. We're saying two different things. Sorry, perjury is if you get on the stand and you say a bold-faced lie. Just something that is just wrong. Say you say I did something, and all the other times you said I haven't not done it. And really, while it's perjury, it really is just an inconsistent statement. Like if you get on the stand and say I did X, but in 2015 you said I never did X, that is what I'm going to impeach. I'm going to impeach you on everything you said in 2015. Meaning I'm going to say, okay, today you said I did X, but in 2015,
Lieutenant Dane.
I don't think we had nobody for that. You now go ahead and read that line.
Sir, we have a security issue. We need to stop for a minute. If we can stop for a second, please.
All right.
I don't know what was told to you on Friday. I have no reason to want you in prison. You have spent enough time in prison for a YSL, period. So why would I want that for you? That doesn't make no sense. I said it to you before. I'll say it to you again in front of all these people. It makes no sense.
But you just said I'm going to have to stay in jail until the last
If you don't testify, get this part through your head. If you do not testify, that is the only thing that is holding you. This is literally the only thing holding you right now is the fact that you keep saying, I'm not going to testify. Well, you haven't said it today. I'm not testifying. I plead the fifth. If you get up there and I want to tell the truth. Like I said before, if you don't recall certain things, you can say, I don't recall. That's fine. I want you to tell the truth. I don't expect you to remember every single detail from 2015. I just don't. No one here does. But what I do expect for you is to answer the question so we can get through this. So you can go home and be with your baby for her birthday. See these dogs deliver their babies. Go talk to your nephews and do other things.
Hold on. How the fuck you know about my dog?
Because you told me.
Okay.
What's wrong?
Man, I'm stressing at a level right now, brother.
I mean, I'm saying
I'm weak. Man, I'm not playing. I'm dead serious, man. Like,
This is what our position is. We do not want him in custody. We want him to tell the truth. We want him to testify. That's what will get him out of jail. And you have to make.
If he decides in 2 weeks he wants to testify, then what?
If he wants to stay in jail for 2 weeks, that's I don't know why you would want to stay in jail for 2 weeks. I have no idea.
Well, he just feels like he's under a lot of pressure right this second.
This statement gonna get them in a lot of trouble.
It is. It sure is.
Bro, even at the fucking jail, they are just, bro. You can't give me house arrest.
No, you can go home by taking the stand and testifying. That's what you can do.
And come back tomorrow.
There's no, we keep on saying yet, but there is no crime. We keep on saying yet. I don't know who is telling you about a crime. There is no crime. You have done nothing wrong except for not.
Rich, so why the fuck am I in jail then?
Because you weren't testifying.
But that ain't nothing wrong. It's not a crime.
It's not a crime, but you are in civil contempt.
2 things. Because you invoked your privilege after you have been given immunity. That is why you are in custody. Because you get out of it by testifying. So you testify, you get out. That is what I'm going to bring you. Why I brought you here early today to just inquire about that. You can remain and hold your position of invoking the 5th or not testifying. You go back to prison. You go back to jail because that's...
Bruh, you can't sentence me.
There's no sentence. There is no sentence. The contempt is compliance. They want your testimony. That is all they want, whatever that may be.
All right, bald head ass nigga. I don't know what it is, Your Honor.
So listen, you're in jail for failing to testify.
Failing to testify.
Not for nothing else. There is no crime. You ain't done nothing. I don't know if people are telling you that we are going to charge you with nothing. We are not charging you. The state charges you. There is nothing we're charging you with. You're only in custody because you have decided not to testify. That is it. Once you decide to testify.
Remember that word you were talking about, purge?
Yeah, dickhead.
Okay, you can purge right now. Purge. Get yourself out of jail just by testifying.
Can I purge and get my ass out of jail?
Yes, just by testifying.
Not perjury.
Purge, meaning you can get out of jail. You can get out of jail, out of custody, just by testifying.
And what about that other word, the perjury?
That's different.
That's different.
That's a different word, okay?
Can that shit get me back in jail?
Yes.
Perjury is?
It's not what you are saying. It's not perjury. What you are saying is what we call prior inconsistent statements. Your example that you gave me. What if I said I did something and I know you didn't do it, and you said before you didn't do it? That's not perjury. That is a prior inconsistent statement.
You've got to make a decision. So if he starts testifying today, he's going to go home today?
He should, so long as he remains. But if you get up there and be like, if you get to testify and then we get into it and you start saying, I plead the 5th, we're going to be back here again.
But if he says he don't recall to everything, he'll be okay?
I'm not advising that. But so long as he answers the question, that's fine. So long as he...
Bro, I did these motherfucking crimes. I'm telling you that.
Oh my God.
Okay, I don't know what you are talking about, but
I think, are you saying you want to get up there and stand and say something?
I did it!
Did we find out that we could talk to his family? No.
I mean, if it's okay, we got the sister's number.
Damn, ho, it's my attorney. You gotta...
Let me, if y'all want to talk, let me go somewhere where I can't hear you. The judge is over there, so just speak really low so he doesn't hear you.
Hold on. Okay, all right, Mr. Copeland. Have you had an opportunity to talk with Ms. Bumpus, your lawyer, and Horrible Hilton, the state's counsel? Have you gotten any other questions?
No, dumbass.
Is it your desire to give testimony today?
Yes, dumbass.
Okay, all right then. Do you all have, do y'all got some clothes for him?
I don't know. Let me go take a look. What size are you?
I can't hear you.
What size are you?
Little.
Funky hoe.
We have a large jacket for him on Friday. Large.
You had a jacket for him.
Yes.
Oh, but he can't wear large.
What is your waist size? 34?
32.
Chest? What are you? A 34? 34 through 36 chest?
Probably 36.
Not in my chest. What you mean?
Size.
Get off my chest.
What size are you?
Get off my
Small or
chest.
medium?
Small or medium?
They are going to try to get you some clothes so you don't have to testify wearing all this jail stuff. Okay?
So y'all don't want to show the people how y'all did me, huh?
Look.
If we can't find clothes, then you may have to until tomorrow.
No, fuck y'all. I'd rather go in like this.
I understand what your preference is.
No, bitch. Don't hide it.
Can y'all make him put on some clothes?
No.
Oh, no, I won't go.
Fine with me.
All right, okay.
And you ain't gonna try to lock me back up for this, is you?
So long as you testify, we will get an order to get you released.
Today? Whose copy is this?
You've got to make sure you come back now. I want to be real clear. Sorry.
Hold on, bitch. When have I ever ran?
You have not. That's the only thing. You have not.
Again, whose copy is this? Who this for?
That's ours. Do you want a copy? You can take it though.
Okay.
Do you still have yours or you threw it away?
I'm going to give him both of these so that he can have some information.
Are we off the record now?
Look at her ugly ass. You been in the cut the whole time, ain't saying shit.
Shut up. Y'all, so you know what I realized? Bump is live because she was not.
Yeah, we ain't done.
Oh, my bad. Go ahead.
No, we about done though. Yeah.
But she lied.
We gotta finish it out. We got a couple more lines. Go ahead, Tasha.
It's the court because I said, "Are we off the record now?" No, it's you. No,
it's with Buckles.
It's you. You never did say okay.
Okay.
Are we off the record now?
Now, what a court reported.
I said, "Are we off the record now?"
Okay, you must be asleep.
Y'all can't hear me?
Yeah, I can hear you, KD. She can't hear you.
I can hear you, Katie.
I
I
said,
can't hear. Okay. Are we finished? Or are we done? Yes, I believe so. Okay, we're good. See y'all niggas downstairs in about 10 minutes.
So you know what I realized? Bump is live. Because she said that man fired her in the meeting. Can y'all hear me?
Yeah, but you know, yeah, we can hear you.
Why can't I hear KD? I cannot hear her.
Go out.
I'm gonna have to exit and come back.
Yeah, I'm gonna let you up, and then I'm gonna.
She don't need to drop the link again.
Okay, I'm gonna drop the link.
Bro,
The turn it too,
what
because
the fuck?
Oh, that's that damn. So that's that damn transcript. See, that's more like, you know what I'm saying, on the lines of what probably was really said. You know what I'm saying? There's plenty of shit that probably was left out. But that's more the lines that what was really said. With they funky ass. You know what I'm saying? We had the perfect people playing the perfect, you know what I'm saying, roles, because you know how they do it. Ugh. You know. Hold on, look at this. Hold on. Damn, get out my face, dude.
That on the Sunday at Cascade Skating Ring, that you got Thug on FaceTime so Kel and Thug could speak. Yes or no?
If Detective Thorpe said I told him that, I told him that.
Okay. Do you remember that happening?
No.
Yeah, y'all
I don't
that's funny.
remember. Me and Shea Kelly ain't gonna talk.
All right.
All right,
And then
hold on.
do you remember telling Detective Thorpe?
Is Tay the same Tay? What's going on? Is it two different Tays or is it the same Tay? Which one is it? Eno, which one is it?
So him and Thug talk, and whatever was said with that, I don't know.
I probably told Detective Thorpe that.
And again, that was in your January 11, 2015 interview.
I guess.
You
want to come? See, Eno said it's the same Tay.
Tell Detective Thorpe about a shooting that occurred at a gambling house in Lakewood.
If that's what he said.
Do you recall a shooting at the gambling house in Lakewood?
Same two people. This stanky breath Hilton.
You recall a shooting at a gambling house in Lakewood?
That's who was stanky breath Hilton.
You do not?
I don't.
Perfect role.
Do you recall telling Detective Thorpe in that same January 11, 2015 interview that there was a shooting over in Lakewood and that it was Kel and he was standing on top of a roof and shooting inside?
I probably did.
I need to know, do you remember telling him that or you don't remember telling him that?
When Detective Thorpe questioned me about what happened, I thought I was in there about 5 minutes. I thought I walked in and walked back out. So I don't know what I don't told him. I can't remember what I don't told him.
So you say you don't remember telling him about what happened at?
But if he said that I told him that, I'm telling you right now, I told him that. So can you start asking me what I supposed to told Detective Thorpe? Because I'm telling you now, if he said that I said anything about anything, I'm telling you, more likely I probably did.
Great. Well, I'm going to ask you about all the things that you talked to Detective Thorpe about. Did you also tell Detective Thorpe about the Friday before Nut was killed?
I guess.
Okay. On the Friday that Nut was killed, were you with Thug the Friday evening before Nut was killed?
No, you just said earlier, was I at the house? I said yes.
I'm talking about the Friday evening before Nut was killed.
All right, so I'm gonna find some real quick. Look at this. I'm gonna show y'all how Lil Woody was looking in this video. I ain't gonna play the music, so I don't mess with it. But look, this Lil Woody music video. Hey, is this Tay right here? Is this Tay? Keep it. Hey, I told you, Tasha. Is it? Yeah. Yeah. All right. Yeah. All right. Now pay attention to how Lil Wood, like, pay attention to his eyes on this video, because of course it's a bootleg video. It wasn't. Well, I ain't gonna say bootleg, but it wasn't just. You know what I'm saying? I ain't gonna say it was bumpy. Look at him right here. This is what I was talking about. Look, you can tell he do that shit for real. Like, look, I watch his eye. Like, you can tell he do that shit for real. Like, bro, you all in the nigga face in the video for real. Like, look. That nigga trying to move his face and some more shit. Like, bro, took that to heart. Look. Look at him. Like, bro, somebody should have told him they just be acting in these music videos. This Tay right here. This is the other Tay. I think is a part of why I said. I mean, part of Lucci crew on the nut. If it is two Tays, I think because it's one Tay that's dead. No, Woody ain't killed him. I don't think Woody killed him. No, I don't think Woody killed him. How did we get here? So I caught the bus. Nobody's supposed to be here. I came to. You know how we got here? Now the trial on pause. Ain't nobody got nothing to do no more, but you know what I'm saying? Speculate. Y'all ask for these transcripts. The judge has to drop the transcripts and get out of Dodge. Y'all ask for these transcripts. So the judge had to drop the transcripts and get out of Dodge. I'm gonna try to find some real quick. This is how it all started. I mean, not started, but this is where we at now. Y'all boy went on there talking. Hold on.
Have any sense of when that decision would come out? I mean, what court it would go to, how the briefing schedule would work, how long the arguments would be. When do you think we could get a resolution of that issue?
Yeah, that's a great question. This is the 4th of July week. The Superior Court here in Fulton County is not going to do anything until.
Oh, you must be off work today, pimping. All right, let's see what Funky Booty Hilton, Hairy Chest Hilton had to say. Funky Booty Hilton. Thought I had something on it. Exactly. Would it. And why he ain't gonna get nowhere with that? That's why everybody getting shot at and dying around him and all that. He getting this little clout from, you know what I'm saying, him acting a fool in court, but I don't know how far this gonna get him though. You know? I don't know. I don't know how far this gonna get him. So her ass come up here.
Until he gets his order entered that he referenced today, the order where he is going to send this to another judge for determining recusal. Assuming he gets that in today, then hopefully it would be, Fulton County moves pretty quick. Hopefully it would be assigned to another judge within Fulton County this week or very early next week. I don't think a judge in Fulton County, though, can actually consider this recusal issue.
And explain to us why, because there's a conflict?
So that's what they talking about.
I mean, I think that if you look at...
Oh, they saying they're going to have to get another judge from a whole nother area, like a random judge. They trying to say that what you calling them cool? The judge, the white lady was cool, or is she cool with him? Or it's just the problem that they work in the same office? Funky Booty Hilton. Or is it the problem that they work in the same office?
I can't say no bad words.
Yeah.
What's your beef?
You keep it professional over here.
What's your beef?
I mean, with Hilton or you?
With me.
Hilton? You as
with
Hilton?
Me.
You off today?
No.
Oh, you working?
When do you think that we are ever off? That's why I'm jealous of Mel and all them talking about they off for the next 2 days. I'm off tomorrow.
Guys, this was the person playing Miss Hilton. This was the person playing the judge. And,
where the judge?
And Bumpus, I think. Yes. This was my lawyer, Bumpus. The honorable nurse.
Bumpus ain't really do nothing for you though.
What you mean? Well, I don't
for
know.
Real, like not. But she.
Bumpus was playing both sides, huh?
Bumpus is very unintelligent.
Definitely.
Her Instagram story, that interview where she was trying to take people into her life, like I could not. She was like, yeah, you know, and you a lawyer? Atlanta is a different breed though, so I don't know.
You said Atlanta a different breed?
Yes, D. Go on her Instagram and play that video.
Oh no, I'm not going on that child Instagram.
You got to.
Oh, I'm gonna have to log into mine.
Oh, you don't want us to see that Instagram?
Man, what else? This is a professional channel.
What be on the Instagram?
This is a professional channel. And then plus she be clout chasing. I don't want to see her in a bikini and all that. She a lawyer. She's supposed to talk about injuries.
Baby, she's showing that body. Now you got to get it to her. That body is nice.
So you got to get it to her.
You do got to get it to her. That body is nice. She paid a lot of money for it, and them teeth. But you know you can get real teeth. You just gotta go to an orthodontist or a dentist.
Oh, let me find.
I hate them big ass chompers.
I'm gonna try to find the last day in court.
You need to go play Mel. I Am Not a Lawyer video. That was actually a good interview, and she asked Doug Weinstein some questions that nobody asked.
Hold on, who?
Mel, the girl Mel Goolsby. I think that's her name.
Never heard of him.
You never heard of her?
Mel Goolsby? What are you talking about?
She's so right. Type in "I am not a lawyer."
As you all are made aware, last week the court was going to do an in-camera review of the ex parte proceedings on June the 10th of 2024. In considering whether or not to have an in-camera discussion or review of the records, this court has decided to release the entirety of the transcript of those proceedings as courts one. And I'm going to take judicial notice of the following timeline. On Friday, June the 7th, 2024, Mr. Kenneth Copeland was granted immunity from prosecution pursuant to 24-5-507A, and that will be marked as courts 2. So the transfer will be court 1. His immunity agreement, Mr. Copeland's, will be court 2. Mr. Copeland, who was represented by information, court's attention, not at the court's request, by security personnel, that video footage of what occurred outside courtroom 1C shows the interactions between Ms. Bumpus, Mr. Steele, Mr. Adams, and Mr. Sharp.
All right, so I just realized he just said what they saw on camera right there, right?
So that's what Bumpus confirmed. She said when she was on lead, she was like, "Now I can say it now because."
I'm saying so. Any
So technically, she's the mole, but she's only the mole of the substance. I believe one of the deputies came and probably told them that it was a meeting, and they probably relayed some of the information, but it wasn't enough for them to get a clear understanding.
And then
I agree.
he said that lunch, they went out there and they probably halted Bumpus and like, hey, what happened? And she just not knowing and told them everything.
I agree with Tasha. That's what I think happened as well.
So, let's let him.
Third outside courtroom 1C
Outside
shows the
courtroom.
interactions between Ms. Bumpus, Mr. Steele, Mr. Adams, and Mr. Sharp. The court in no way sought to investigate.
Hold on, why he didn't say Weinstein?
I don't know, because Weinstein said that he was there, but it kind of don't make sense though, because all of them couldn't have been there.
But hold on, maybe he just left Weinstein there. I don't know.
Investigate any facts of this involving this footage.
And
only considered it for the security and timeline of events that occurred on June the 10th of 2024. Also, in no way did the court consider any of this footage in holding Mr. Steele in contempt. And as I said, mentioned it only for the purposes of considering the security and breach of information that occurred within the court's chambers, not for whether or not that was truthful or not. Mr. Steele makes further made three assertions on the 10th of June of 2024. One, he asserted that this was, on behalf of Mr. Williams and similar situated individuals, that this was the court held an improper ex parte meeting. Secondly, that Mr. Copeland was a sworn witness, and this was a critical stage. And now, Mr. Copeland was a sworn witness, and third, that he argued that this was a critical stage and that he.
Doug knew it was going to be over with quick, and he wore anything this day. Bro ran the court.
And the others needed to be present at that point in time to pursue the Moran at 6 waiver by defendant requiring a trial. However, there were no
Bumpus lawyers.
Attorney Bumpus disclosed confidential or attorney-client matters. The court takes no position on whether Attorney Bumpus violated the duty of candor to other counsels involved in this case. These two questions can be resolved by the State Bar of Georgia and our Supreme Court. The court further takes no position on whether Mr. Steele, his use of the June 10th proffered information.
Did you hear him say, and I didn't catch that, he said that the State Bar can take up for Kayla Bumpkins violating attorney-client privilege?
Let me see.
Attorney Bumpus disclosed confidential or attorney-client matters. The court takes no position on whether Attorney Bumpus violated the duty of candor to other counsels involved in this case. These two questions can be resolved by the State Bar of Georgia and our Supreme Court.
Oh, so they all.
He's going to report her. He's going to report her.
But do y'all think they're going to do anything?
I don't know. I mean, you got to think though, coming from a judge this is not coming from like a client. This is coming from a judge. So, but I'm sure they're going to be aware of the situation, but I'm sure it's going to be escalated, and she's probably going to have to fight because, like, we don't know what all was said in that meeting because it seems like at some times, like, they weren't even making full sentences, and like, how do you stop making full sentences?
Hold on, did she say she was fired in the meeting?
She said she was, but we didn't see that, so she had to be fired during the time where they weren't on the record.
But that wouldn't be that. Would that be still considered the meeting? She wasn't fired in the meeting then.
Not technically, because the court reporter only starts when it's saying we're on the record. So that's when she starts to like type.
No, I said this the other day. Why would Miss Weaver be asking, "Are we on the record or are we not?" Why would she have to ask that?
Because
is that a normal questionnaire?
She can't type when they're off the record. So if he says,
but why would they be off the record though? Is it? The question is, are they allowed to be off the record?
I mean, yeah, they're allowed to be off the record. Like even when he is coming to his, like he's sitting at his desk and he's saying, "Well, we're on the record now with,
Look what
you know."
Sierra said.
Yeah, I mean, Sierra, it is no attorney-client privilege, but at some point in time, they're saying that he was with his attorney by himself. So what he could say is that she relayed some of that information to them.
Oh, they saying Libra said she said before the meeting she was fired.
But she hadn't seen him before the meeting, so that's what's crazy. Unless she's seen him.
If we're
because she said that.
Are we in agreement that we all think that there's something missing out of the transcript anyway though?
Definitely redacted.
It's a lot of stuff. I don't think it's redacted though. I just think that he excluded a lot of stuff from.
Well, yeah, like a lot of stuff.
Yeah, but I think that's what everybody mean by redacted. Like some was taken out.
Some of it's left
but
out.
you know, redactions is basically blacked out, so it's still there, but it's blacked out so you can't see it, so you'll know that something is there. He excluded it, like how Love said you would have had to deliberately take it out. He deliberately took that part out.
Oh, you think he hiding it?
Yeah, because if it was redacted, he would it would have literally been like this. Like I done wrote something on here, and this is a redaction. You see it?
Yeah.
So all of that'll be blank. Like it'll be so many like black lines saying, "Okay, I'm taking this out because I feel like this is attorney-client privilege." But I mean, the whole conversation is crazy. I don't believe that. I believe Steele over-exaggerated a lot, but he had the right to.
Hold on, you said he had the right to?
Yeah, he had the right to, because I mean, at the end of the day, you know, you got to advocate for your clients. So, in a sense, where let's say you were my client, right, and I knew something was going on with you, and I knew this was serious. I'm gonna put what I feel like that should be on the record there. We can dispute it later because, in a sense, somebody had to come back and say that he said something about murder. They never said. I don't believe they said whose murder, but you got to think. We're talking about Donovan Thomas murder. So, of course, in my head, I'm going to allude to this is the reason why he said this, because he's saying it's no statute of limitation on murder. I believe that when Steele cross-examines him, he's going to say that you killed Nut, because he knows that he killed Nut.
Well, he already said with the first thing he gonna ask him, or one of the first things gonna be what happened in that damn meeting, and is this everything that was said? You know what I'm saying? That type of.
I just wonder why the judge changed his mind.
About what?
About the transcripts, about the in-camera meeting, about like everything. Like it was just out of nowhere.
Because I believe that if he had that in-camera meeting, I just feel like everything would have came out. Like Kayla would have had to say what was said, and it wouldn't have looked good either way.
Well, she wasn't there, so she wasn't gonna say that anyway. She didn't even go.
Well, she probably could have been like, well, I don't know. I just feel like, I don't know. I need her to get on somebody's channel and discuss what the inconsistencies were with this transcript. That's what I need.
What happened to her going on lead to discuss the transcripts when they dropped? She made me mad because that was the only reason I watched that 6 hour long. What is juror?
Name
Say it, D.
Jurors.
Jurors. Jurors.
That's the only reason I watched that.
Look. Name one dude who was actually active that's trying to, you know.
Y'all keep asking me, do I recall this, recall that, remember this from 2013? I don't remember never 2013. I keep telling y'all that. That has been my statement since I got here. Your Honor. I've been telling y'all, people constantly hit me with this, keep constantly asking me this and that and third about what's going on in 2013, whatever. I don't remember. I don't know nothing. All I can tell you is y'all got my name on a recorder, my phone number on a recorder. These people threatening me. They calling my phone. Your Honor, I done lost my job. I got a lot going on behind this here. I put all this behind me, sir. Everything that had going on with me, I put everything behind me and kept moving on about my life, sir. Your Honor, I can't continue to keep going on like this. I don't remember nothing from 2013, sir.
That boy put it behind him.
You have to answer the question.
He stood on that.
I ain't gonna lie, I felt sorry for
keep telling
him.
y'all, I don't remember nothing from 2013.
What'd you say?
I felt bad for that man during that. I ain't gonna lie.
Hey, I feel bad for him too because shit, he tried to play like he had COVID and everything just to try to hide his identity. Like, bro was getting up there, bro. They had boys.
I don't feel bad for him, D. That nigga say I don't remember nothing from 2013. That nigga remember everything from back then. You
Bro,
from back then.
He was trying to get home to his wife.
But
I thought that man was finna cry.
It was really messed up though that they put his phone number out there like that. That was messed up. Like I feel like the state did all of that stuff intentionally. Even like recently when they was about to start releasing numbers and they was like, hey, no, like don't do that because they are literally putting people's phone. You don't think these people gonna call like
no, but to their benefit, if you don't remember them from 2013, you should have a new number at that point. Like you shouldn't have the same number. You still active, son.
Bro, some people don't change their number, D.
All right, well, the same folks from 2013, the same folks from 2013 probably still calling him then.
Listen, he probably still running them same plays from back then. You feel me?
I'm going to ask you because I have to lay a foundation.
Look how you looking, bro.
Do you remember
Man,
telling
we look
Detective
so
Quinn
disgusted all the time.
September 17, 2013 on recording that you add a little more hype when you speak with your wife and them from the jail, that you lied to them?
I remember y'all trying to assassinate me right now in 2024. That's what I remember. That's what I remember. All this going on right here on this, got me up on this stand, talking about this and that third, all this extra stuff that's going on.
Hey, that's the second and third casualty. And we're going to pray that
Sir,
that doesn't
you just have to
happen.
answer the questions, unfortunately, at this point in time. Okay, that's all I can tell you.
Am I on trial?
No,
Am I on trial, young?
But you have been properly summoned here as a witness, and you're subject to examination.
I never consent to do none of this, sir. I ain't signed nothing. My name ain't on nothing. They come get me. They y'all don't threaten to lock me up. Hey, I got a family too.
He got a family too.
I sure hope that man got out of
come on,
Atlanta.
I told y'all I don't remember nothing from 2013.
I think he good. I don't think nobody messing with him.
Come with these conversations. Hey, remember we was in front of the house?
Remember what you said?
Conversation we had in front of the house before we went to the Kroger. Keep it 100, man.
Keep it 100.
With yourself.
I can't hear you, Mr. Bean. Can you take your mask off if you wouldn't mind?
Keep it 100 with yourself.
He still said it the same way. The whole.
We had a conversation in front of the house.
Bro, did y'all expect him to look like this when he took out the mask?
Heck nah, he's just like an old school gangster. He old for real. He probably in his 50s.
Yeah, you asked to go to the.
I never agreed to do none of this from the beginning. Before we even had this, what you just played.
He made beginning 2 words.
I keep telling y'all, I remember
You
that
see his
from 2013.
face,
I ain't really
though?
remember that
He
then.
look so serious. Them boys look scary.
Lock you up.
Sir, I talked to you on.
I don't think none of them boys nothing to play with on.
Sir, answer.
I'm on trial for anything. Can I be excused, Your Honor, for anything? Something? Because I really don't understand what's going on. I don't remember. My head hurt. They keep asking me questions about this. Keep asking me questions about that. About 2013, I don't remember.
No, you can't be excused at this point in time, Mr. Bean. You have to be. You're subject to examination.
He was stuck. Look at him. He ain't moving.
I don't remember.
Who you just told the jury, the Honorable Judge Glanville, and all of us that you've been threatened to be locked up.
I didn't consent to come get on this stand to be a witness, first of all.
Who threatened you to lock you? Lock you up means go to jail.
There wasn't no threat. The subpoena go out. They say you don't show up, they're gonna lock you up and go to jail or whatever, and all this little extra stuff like that right there. I ain't here to point fingers at nobody, say nothing like that. That ain't my job.
You just said
it ain't for me to mention what nobody got going on in their life. I got my own problem.
Who threatened you? You just told the jury that you've been threatened.
I done had all kind of threats, man. Y'all just explored my whole phone number on to the world. People calling my phone right now threatening me, texting my phone. I ain't had no sleep. I've been up all night since yesterday, 7 o'clock, from 7 o'clock yesterday to 6 o'clock this morning.
How did I miss this?
Still getting calls. Still getting
Me
texts.
too. I missed that too.
That's my personal line y'all just gave out. On live to the public, to the whole wide world.
That nigga pointed to the camera like y'all.
He pointed to your girl.
Who threatened to put you in jail, Mr.?
He's answered that question already, Mr. Steele. Let's move on from that.
Do you remember telling Detective Quinn on September 17, 2023, that when speaking on a jail recorded lines for your wife, I'm visualizing the story, trying to make it all one. You know what I'm saying? I ain't telling them a lot. A little shenanigan be bold blank. Remember saying that?
Ms. Love already asked me 1,001 questions. I told her I don't recall nothing from 2013. I don't even recall the conversation really that me and you even had. If somebody else push up on me, ask me questions, let somebody else come to. I give them a story too. Everybody gonna keep asking me questions. I'm gonna move on with my life, man. I ain't got time for these games. Y'all done assassinated me, man. Hey, it about time for some actions now.
What type of action?
I'm all on all these blogs, all these channels, my face all over the news, everything like that.
About time
Keep
for
on
some
asking questions. I'm telling you, I don't recall.
Keep on playing with me.
Okay, well, I just have to answer these questions. Do you recall telling Detective Quinn on September 17, 2013, that on jail calls, that you bold blanked around with your family a lot, bold blanked around with the story a lot?
Mr. Steele, for the completeness of the record, you need to say the word evil.
They got tired of him not saying. Mr. Steele had to go and say bullshit.
Go to D'Angelo White. That's the nigga right there. That's when I started watching.
Oh, you came late.
I did, man. I wasn't watching this. These people are doing too much. It's 7 p.m. Friday.
They all had me tripping.
Why is I'm here? That's what I keep asking.
Well, White is the one who died.
No, D'Angelo the one on the stand.
Yeah,
Why
find that video, D. Find that video. Why is I'm here?
Why is I'm here?
Oh, his name was D'Angelo White.
Mm-hmm. He was in a car. He was the one that asked the people for the $20. Remember the snitch. And they didn't give him nothing. They would have had to give me them 20. I ain't snitching for free. Sticker. Man, these YouTube streets is quiet.
Right,
what's going on?
That's why I said, is this what's it called? Who is this?
Who is it?
That's why I thought D'Angelo White must be dead. No, that's somebody else. Hold on.
Man, I did hear them $20 shaking. I ain't gonna even lie to you.
What's Slit talking about? Who is Big Fred?
Now I don't know.
Oh yeah, AB.
Listen, I seen Nurse, Mel, and Slick got gifted memberships over there on the lead. They now jurors.
Jurors.
Did your skin be crawling?
What day was he up there? Who? What?
Let's say your skin be crawling.
Crawling.
Yeah, when you be hearing lead say jurors.
Oh hell yeah. No, especially when you say King Slime.
That nigga so fruity. I don't care what nobody say. He is ass up. He is very gay. Let me see.
I hate when a man say that. King Slime.
He want that slime.
I got mysteriously pregnant with twins. I was
shoot. Sorry, y'all. I'm trying to find the D right there it is.
His name, y'all said his name was D'Angelo White?
Yeah, but I think you're just spelling it wrong. Well, I want to find them so backwards. So they got Jeffrey Williams to the back. Now they got a lot of trials that's on every day.
I'll show y'all a tick while you find that. Find the what you call it, dude.
How long was Tick on the stand for? I can't remember.
A few days.
Oh, a few days.
Probably like 3 or 4 days, honestly. Oh, well, he was on that 2 months ago. So it's when he had this sweater on. Dang, it is this sweater. This a clip. Hold on, I'm gonna send the clip to you.
What? Who?
I'm finna send the clip.
What?
And what's the name? And you look at the cord on what you on right now? You look at your server?
I mean, yeah, I can look at it from not on her. I mean, I can, but I'll look at it on my phone.
I send it to your phone. It's the 3-minute one.
I think it's this part. Somebody said day 57. Oh yeah.
You found it.
Okay. Is everybody out of work today?
Not me. I'm still here. After today, I won't be back until Tuesday.
So petty, D. Look at the chat. You know I was in Memphis. Stop playing with me. D, did you say that I came to Memphis to visit you?
Did you say?
Did you tell I came to Memphis to visit you?
It's him. It's him right here.
I don't even supposed to be here. Why is I'm here?
Oh, that's right. They never did show him.
They never showed him. That's why I can't find him. I'm looking for his picture. They never
I just
showed
wanted
him.
to ask you, do you know what that street is on the bottom that's in that photograph before you and on the screen to your left?
What they got to do with me?
I'm just asking if you know the street, sir.
I don't even supposed to be here. I just keep asking you the same thing.
Ms. White, do you know that street on the bottom, 54 Bravo Bravo?
Yeah, but what it got to do with me?
What street is it?
You see what it say? It say John Bay Road.
Yeah, man.
You see where, you go to a gas pump, they'll have the neon lights with the price of gas. You know what I'm talking about?
Yeah, what about?
You see that red and green neon light kind of back of this photograph?
Yeah.
What's that road that I say perpendicular from the Jonesboro Road we just talked about?
I don't know.
Is it Brownsville Road?
Which one?
Which one? What?
He said some reenactment. Yeah, that's D'Angelo White. They ain't show his face.
Oh, she's saying, why don't we do the D'Angelo White reenactment?
Oh,
that's what I told Katie. I said we need to pick one of the court, like one of them little court, like clips, and then reenact it on her channel. I think that'd be fun.
Yeah, we should. I want Dee to do the steal. Don't take my notes.
No.
No.
You got 5 minutes. 5 minutes.
No.
That nigga sounded so snippy when he said you got 5 minutes.
Hey.
Tasha, you be Judge, you be Love, and DB Steele. When they got into it that day.
I don't like this.
No.
Y'all. You know what though? Honest to God.
Your Honor, you have let this bald-headed bitch say this shit 3 times in this trial.
First off, I would never. I would never. I've never. The state has never threw such outlandish statements to the defense. And Your Honor, I would like for you to strike
Hold on, did
that
Kayla ever go on they page and go over the transcript?
No, that's what I'm saying. I was mad. Like, why y'all went over it? AB already had went over it. Why we went over it again without Kayla?
He said he said he had texted her too. I guess she ghosted him.
He was trying to take her to Fogo. That little cheap $49 restaurant.
She didn't want to answer them questions, them 3 questions.
I don't think she could. I think she jumped the gun when she got on there the first time right after that case. She shouldn't have. She doing too much.
So the white lady can't try over this case.
What you said, D?
The lady, so can't nobody in Fulton County try over this case? Like they can't give it to nobody in Fulton County?
They're trying to get them to I think to let it go. I haven't checked Thugger Daily today, where all the bloggers get their information from.
Y'all remember somebody tried to get Thug some drugs in court?
That was wasn't that Pee Wee?
I think so.
Yeah, I think that was Jamie Winfrey.
Ain't that the one with life?
Yeah,
that's
but
the one
no,
that
that's the
said
one who got his case overturned. That's still quoting his his new thing, but he only got 10 years. He took a plea deal.
That was for the Lil Wayne Bush shooting, right?
But you see, they got until Monday.
That was for Lil Wayne Bush shooting.
KD needs to be on document duty.
No,
didn't he get it? Did he get that turned over for this bus shooting, or was that for something else?
I'm thinking it was for something else. I think he got a real murder. I thought he had a real murder.
She did do a interview on the Shade Room, but she did it right after she got off of
Kayla, I dropped it in Discord.
She did an interview with the Shade Room.
Yeah,
it wasn't that like good. I'm not gonna lie to you. Like it
looked like we done seen that before.
No, I don't want to see it on her then.
Oh shoot.
Yeah, she gonna come up with something. Talk that law said he been trying to get her back over there. Y'all know who that is when we went over there?
He was on her first. He was on there. She was on his channel first. Man, he monetized now. Y'all remember that day we got over there and y'all cut up and that man had to private that channel, that page.
That was what's her name?
So D, this what be happening in Fulton County.
Yeah, it sound like Fulton County crooked as hell. They ain't got no control over their court system.
None. That's crazy. I just have never seen anything like this happen before.
Oh, Kayla said that hold on, Kayla might not be lying. She said that when she was trying to approach that she was gonna tell them that she got fired back there and they know that. So it might have been something that's left out the transcript.
But play that clip, D, when she was talking to Love and Houston, and she was like, y'all need to say something. She kept saying that to them. Now I can give her credit. She kept saying that to them. She was like, y'all need to say something. Yep. And that's why Houston had said, Your Honor, we really don't need her. Like, but she didn't say, okay, she was fired. But I feel like they knew that he had let her go. And I think they wanted him to let her go. Get up out here. Let's dance.
That was the day she had that green on it.
Mm-hmm.
Yeah, I gotta find what that is.
That
was the next day after day 89.
Yeah,
because 88 was the day that still got held in contempt. 89 was the day that Kayla had came back from the airport after she tried to haul Taylor. Baby Kayla was like, I'm out. I wish they would have let us see like two different views. So the view from the court, and then the view in the audience, so we could see her get up and haul ass. Cause that shit would have been funny.
She's fired.
She's fired? Okay.
She fired.
She's
fired. Your desire to release your counsel at this point in time?
She fired.
She fired.
She's fired? Okay. So you wish to represent yourself in these particular, in terms of any issues you may have in this particular.
Do I got a choice?
I'm sorry?
Do I got a choice?
Yes, you do.
And what are those?
You can keep your lawyer that you have right now.
I don't want her.
What are those?
All right. You could certainly hire another lawyer, or the court could appoint you a lawyer.
What I need a lawyer for?
No, it's just the court is just asking you whether it's your choice, sir.
I'm good.
You're good?
Yeah.
Ms. Bumpus, did you file an entry of appearance? All right. Did you, under the Uniform Superior Court rules, file a motion to withdraw pursuant to the Uniform Superior Court rules? I mean, I know you give an oral notice, but usually it has to be in writing, and he has 10 days to object.
Well, Judge, just for the record, I was never his counsel.
Say again.
I was never his counsel. Attorney Melnick was his counsel, and I was stepping in as a courtesy.
This was the airport outfit, huh?
That was I had to get up and get her for two different reasons.
Given the fact that you have represented Mr. Copeland at this point in time, it would seem appropriate that you do need to, in fact, file a formal withdrawal. Even though you didn't enter one, you de facto entered this case by your representation of him, or you telling the court that you did, in fact, represent him. So at this point, I'm not inclined to release you until that's done.
I'll get that done now, Judge.
Okay, all right. And he's got 10 days to go ahead and do that. So you're still going to have to be here until I have because he gets that particular period of time to go ahead and decide whether or not he'd like to hire a lawyer. That's the whole reason for the 10 days.
Well, I don't want to hire no.
Hold on. Not yet. You get that right as a party. Okay.
Right. Yes.
You get that right to hire a new lawyer. You get the right to do a couple things. One, to decide whether or not you can release her.
Okay.
Okay. Two, you get to decide whether or not you want to get another lawyer to be with you.
Okay.
Okay. Those are the two big things you get a chance to kind of decide. But what I'm going to do at this point in time is, since she's representing you, I'm going to make her file a formal notice to withdraw. She's orally told you at this point in time she wants to withdraw, but you're on the stand, you're testifying at this point in time. So I'm not going to let her withdraw at this point.
Well, Your Honor, I just like to say, before he started testifying, I was fired.
I don't know that, ma'am. That's not something that I have notice or knowledge of.
Look how she looked when he said that.
That's the whole purpose of the knowledge of. So, that's not something that I have notice of. I don't know that, ma'am. That's not something that I have notice or knowledge of. So, that's the whole purpose of the rule, so that we can flesh out all those things. So at this point in time, I'm not inclined to let you go at this point. I'm sorry that you put yourself in this particular situation with you and Mr. Melnick and whatever, but, Mr. Copeland does have rights in this particular circumstance. So file a proper notice to withdraw. I'll give Mr. Once it's filed, if you file it today, I'll give Mr. Copeland the 10 days, but until such time as I rule upon that and he gets that and gets an opportunity to think about what he'd like to do, I'll go ahead and insist that you remain with us while he's on the stand.
Okay, Judge.
Okay. Madam, I have one other bit of business that,
Can we approach? Can I approach her with the state?
no.
It's no for me.
What does he want to tell me?
I don't want to say it in open court.
Look, she about to
What
say
does he
something to
want to
them
tell
right
me?
here. Look, when she
No.
walked.
Madam, I have
look.
one other bit.
She about to say
Okay.
something, look.
Madam, I have one other bit of business.
Y'all seen that?
Can we approach?
She should have told
Can I
it all
approach
right
her
then and there.
with the state?
No.
Look, she mad as hell.
What does he want to tell me?
I can't.
That's all deep. So that's where we at with it. But he didn't call the dogs off of her.
Kayla should have started singing right then and there. The minute he told me no and I want to
Man,
approach, I'm
what?
finna tell it all.
Man, what? But she was trying to save her friend. That's why she was trying to run to her and be like, bro, you need to say something. But Hilton ain't gonna save her. Not in this trial. They fighting for reputations right now. Yeah. Them are all the folks who acted a fool. She can't say nothing too crazy though. But he did say it was a game. He did throw up the game sign. That's what it is. All long we been on here?
2 hours and 51 minutes.
All right. Y'all ready to go in the cut? Y'all ready to go in the cut? We've been on here long enough. I can't run my thing all day. You know, I gotta limit this only for good content. So we can go in the cut so something else jump off. I think we done did our thing today, guys. Kick shit and all that. What Tosh? What you doing? Oh.
I'm on my way to Memphis. I'm gonna take a flight.
Right, you and that naked ass dog stay down wherever the hell y'all at. You and that naked ass dog.
Luca, hold on. Let me tell Luca that you on him. Luca, I got stuff on my face. Luca! That nigga ain't say he ain't fucking with me.
Yeah, I bet he trying to look for some hair.
D, now you know that is a weak spot for me. I'm sorry, I got this shit on my face, but I don't even care. This is a weak spot for me. You know they messed up my dog haircut, and you want to play.
All right, y'all. We might pop out later if we got some, you know what I'm saying, something going on. But y'all know
We'll pop out on KD channel or somebody else's channel. That way we don't have to overflow yours.
I appreciate the game. Bye, you and the naked dog. Bye, nurse. I'm in the cut with you.